Counsel, our jurors are lined up in the hallway behind me. My understanding is you wanted to speak. Mr. Cloud, did you want to speak with me?
Not two. I think we're going to do some stipulations. And did you review the redactions in Exhibit 4?
And Exhibit 4 was the, I looked at, Exhibit 4 is the plan, right? The communication plan? Or no, is that the left? No.
Defense Exhibit.
Defense Exhibit 4, or is that the?
Yeah, it's Glenn Lineberry's email to, actually, Mr. Rossetti, but to Kayla's office. So
Okay.
3 is the original, 4 is the redacted version.
And so are you going to ask to have that admitted or use that as impeachment?
So, I suppose it would be considered impeachment evidence. I was going to show it to him. If he fights me on it, I was going to publish it.
Okay. If you want to, I don't see an issue with you impeaching him with it.
Okay.
I don't, if in fact he disagrees with it, we're not going to have a mini trial on it. If he disagrees, you can read it to him. Did you write this? And if he says yes or no, you're stuck with the answer.
Right, but okay.
But I'm not going to let you admit it or publish it. But you can cross-examine him with it. You can read it to him directly.
So it's his statement, so it's not hearsay. What's the objection to it? Is the state objecting to it, first of all, and why is it not in this? It's not hearsay. He wrote it.
Well, no,
it is hearsay.
It is hearsay. It's an out-of-court statement.
I understand that, but he can testify to exactly what it says and lay foundation for it.
But just because he can lay foundation, that's different. Are you going to object if it's offered?
I'm rejecting based on hearsay, Your Honor.
Okay.
If he wants to impeach him based on prior inconsistent statements, that's removable.
Yeah, you can show it to him. We have it ready on the tablet, and you can ask him about it. You can read it to him, but it's not going to be admitted.
Okay. So I redacted some of it so I can show it to him. That summer 21 paragraph.
I'm not sure you need to even show him the I don't know why he would necessarily need to have. You can show him redacted or unredacted. I'm not sure that matters.
I'm still trying to figure out how to review it from my case lines. Can you send it to me with the redactions? Because I still don't know this. Thank you.
This is your exhibit. This is all the way down to the bottom. Again, okay.
Yeah. So I am.
You need to go back.
Okay.
You're old now. And you have to select it's called combined bundle. When you log in, it says combined bundle.
Okay.
And then you're looking at the top and you have to touch mine and
Okay.
then it'll drop down.
Okay. Government.
So bundles.
Okay, shared one.
Yeah,
So, right here.
so
This one.
that's it now. We'll go through review.
Okay.
And then it should say shared or combined.
Let's get on to it. It's still design. This is why I'm having an issue. I should see what he's talking about.
So, Mr. Cloud, if you're just going to ask him to impeach him, I'm not sure why you would need to have a redacted version. I mean, you can use whatever version you want.
So I asked that it be subject to the previous rulings. So a lot of that information just goes into the background that we've already agreed that doesn't connect.
My previous ruling about impeaching with his prior litigation history, et cetera, it stands.
Right.
But I assume
all
there's
the public information about him.
Mm-hmm.
Yes. Okay. Okay. Are we ready, counsel? And Ms. Evans, you're ready for you have your all hooked up on your computer for your opening?
Why is this 04.shared bundle on the top line?
Yeah, my only issue right now, Your Honor, is that I'm not able to view defense counsel's bundle to review the redacted version. Okay, shared bundle.
And I don't think, do we need to do that before you give your opening?
No, I just might go smoother.
Well,
There you go. Well, now I can see what
Change.
Oh, okay.
Share.
Is it shared? We'll wait for it to load. Let me try this one. Change.
okay, let's
As long as we can have a break before.
before cross, right?
Yeah.
Okay. If we haven't figured it out, I'll give you a break before cross. Okay, let's bring in our jurors. All right. You can go ahead and sit down. They're standing for you. Okay. Please be seated. I'll note the presence of our jurors. Good afternoon. Welcome back after lunch. Thank you for coming back. I never take for granted that you all come back, although I haven't had anybody recently not return, so thank you. Okay. Ms. Evans, are you ready to give your opening?
Yes, sir.
You may proceed.
I need to put that. Might do this so I can see what's going on. All right, good afternoon. I hope you all had a good lunch. So, let's start by talking about why we're all here today. So, we're here today because in July of 2022, the defendant sent 3 emails in violation of a valid injunction against workplace harassment. But those emails were just the tip of a very large iceberg. And that's what we're going to start by talking about. Here I have a timeline of what happened to try to help give you a frame of reference for why these 3 emails were harassing. Now, on or about August 25th, 2021, the defendant was placed on a parent contact management plan, or a PCM, by the school. It doesn't really matter why she was on it, but the school felt it was necessary to make sure that the school and the parents were able to communicate in a way that was productive for everybody. Now, on or about November 10th, 2021, the defendant emailed the school to say that she was going to be attending all of her son's games. Now, in the PCM, it specified that she needed to email the school at least 2 days in advance of when she intended to come to the school. This way, they could plan for her arrival and make sure that everything ran smoothly. A single email saying that she was just going to come to all of her games violated that plan because it didn't really allow them to properly prepare. So, around November, the school's attorney sent out a cease and desist letter that let her know that this email wasn't enough and that she needed to send an individual email for each event she planned to attend. Now, in retaliation, the defendant decided to send out automated emails that would go out regardless of whether she intended to attend. And these emails went out almost daily. Additionally, on May 10th, 2022, she announced in an email her exact intentions for sending these emails. So you will get this in evidence eventually, but what's important to note here is that she said, "I'm sorry that the emails have become time-consuming and bothersome, but I'll remind you that I'm complying with the parent contact management plan you yourselves approved of." She then admitted that she would be sending automated emails for every single event, regardless of whether she planned to attend or not. She said, quote, she would be sending these automated emails until my children graduate, the ban is lifted, or the World Wide Web crashes. She used a program called Boomerang to send out these emails, and these emails would often be sent and received in the middle of the night. And this was particularly troublesome to Principal GLEN LINEBERRY. GLEN LINEBERRY was very dedicated principal to his school, and he made sure that he kept his cell phone nearby, and he would monitor these emails at night just in case there was an emergency. Because sometimes a parent would send something out in the middle of the night to let the school know something was going on. Sometimes children were on school trips, and there might be an issue during one of these overnight trips. He needed to be kept informed. So getting emails in the middle of the night would wake him up. And this was in the middle of the night, every night, at different times. So he couldn't properly plan to ignore certain emails at certain times because there'd be emails sent at different times in the middle of the night. The school's attorney sent out another cease and desist letter to let her know that if she kept sending all these emails, because they were numerous at this point, that they would be asking for an injunction against workplace harassment. She did not stop the emails. They kept coming. And if these emails weren't responded to, she would get angry. So the school administration had to respond to every single email that she sent. And she would send emails asking to attend events she never intended to go to. She would ask to attend events more than once. She just kept sending them. In fact, she would ask to attend events that didn't even exist, as long as the emails went out. So on June 27, 2022, the school district, through their attorney, filed for an injunction against workplace harassment. And that was granted on June 28th, right there, 2022. There was very specific requirements in this injunction because they didn't want to stop her or her children from coming to the school. They just didn't want to get all these emails. So part of this was that she not send automated emails and that she only emailed during business hours. This injunction was served right here on June 30th, 2022. So that means the defendant had in her hands a court order in no uncertain terms that she could not keep sending automated emails in the middle of the night. But that wasn't enough. Because as she put it, quote, "They cannot shut me up." And here's where we finally get back to the tip of the iceberg and why you're here today. Because on July 3rd, 2022, after she had that injunction, another email went out. This one went out 12:01 a.m. At this time, school wasn't in session. It was out for summer break. In fact, one of her sons had graduated, and she was planning to pull the other one out. There were no games. There were no events. There was no reason to send this email. July 4th, the 4th of July, a holiday. Second email goes out. Again, no events, no school, no reason to send this email. It still goes out. And then again, the very next day, July 5th, another email. Still during school break. There's still no events. There's still no reason to send this email. And this email goes out at 1 a.m. So finally, on July 5th, the school had enough. They contacted their attorney. They let them know that the emails were still coming, and they contacted the sheriff's office to let them know about the violation. And on July 10th, 2022, Deputy Wingate went and spoke with Michelle, the defendant. And she admitted during that conversation, she was using automated emails. And she admitted she had no idea if there was any events going on. The events were going to get sent, the emails were going to be sent regardless. Here you'll see the 3 emails that were in violation. At first blush, they look very innocuous. I'm requesting to attend any event Gavin and Justin may be participating in, but there's no event. I'm requesting to attend the game on Wednesday. There's no game. I'm requesting to attend the game on Monday. There's no game. All games had stopped by May 14th. But it's not the content of these emails that makes them harassing. It's the volume. It's the fact that she sent them every single day. The fact that she didn't care whether or not these were actually asking to attend something. She just wanted to send them to the school to harass them. And the fact that these were sent after the injunction against harassment was in place is the reason we are here today. After you see all the evidence and you've seen the entire iceberg, the state is going to ask you to find the defendant guilty of all 3 counts, 1 for each of those emails. Thank you.
Mr. Cloud? Madam Clerk, can we go to a different non-distracting screen, something simpler to Okay, Mr. Cloud.
Thank you. Ladies and gentlemen, Michelle Pettitt is an innocent woman. I want to say that again. Michelle Pettitt is an innocent woman. She's innocent because she sent automated emails in response to what the school requested from her. She sent those emails with no intent to harass GLEN LINEBERRY, and at the time of the 3 emails in question, July 3rd, 4th, and 5th, she didn't even know the emails were still going out. But you don't have to take my word for it. Let's take my client's word for it, because that's what she told Deputy Wingate when he first contacted her.
You don't have the audio on. Can you turn it off?
I don't know. We don't have the, do they have control of the audio on this?
It worked on the bridge.
Does he have it set up for headphones now?
Oh, you could have, because you had the headphones over there.
Can't she click the button?
Deputy Wingate will testify that's his voice. He went by my client's office on July 6th, and that was her statement. I didn't even know they were going out. Are they automated? Yeah, they're automated. Now, how is that possible? Well, the facts in this case, I would say, are really not that complicated, and to some extent, they're not even really disputed. The school asked Michelle to email them 48 hours before she attended any event on school grounds. She has 2 kids. There's an event on the school grounds nearly every day of the week.
Just hold on a second. Do you need a moment, sir?
No, just fine. Sorry.
Okay.
Do we understand?
If you need to take a break, let us know. Otherwise, I'll let Mr. Cloud continue. Okay.
She has 2 kids in the school district. There's an event on the school district grounds nearly every day of the week. So she uses an app called Boomerang to send automated emails. Once the emails are programmed, she never has to touch it again. Set it and forget it. Now, the overwhelming evidence in this case will show that Michelle acted at all times to comply with her understanding of the parent contact management plan that was put in place by the school. So the obvious question that should be in your minds is, what is a parent contact management plan? Well, essentially it's a plan that the school made up to limit their contact with Michelle. And why would they want to do that? Now, as you can imagine, this case has a complicated history. The complicated part is that iceberg that sits under the water that you can't see when the state just gives you the tip. We're going to try to expose the rest of it here. This story starts with my client going to naturopathic medical school. During those 4 years of her life, she had to live down in the valley and go to 10 to 12 hours a day for 4 years, while her children and her husband lived in Miami. Needless to say, during that time, her kids were 4 and 8. She missed a lot of her children's events. Now, she graduated from school. She returns to the Miami Globe area, raises her children. Now, during a custody dispute with her older son's father, GLEN LINEBERRY writes a recommendation, gives it to her son's father, who had just returned from out of state. He uses that recommendation, it was an email, in the family court case against Michelle. Needless to say, she's not very happy with Mr. Lineberry about that. So, using a public forum, Facebook, she vents her frustrations. She makes it known in the community that she's upset the principal that knew her and didn't know the father intervened in the family court case. She makes a post on Facebook, and people in the community reach out to her. And they said, oh, you're upset with Mr. Lineberry. Why don't you check out this public information about him? She sees this public information, and she says, oh my gosh, that is concerning. This man is the principal. He's got access to the school's budget. He's also the economics teacher. She's concerned. So she takes it and she posts the public information on the Facebook. She also takes an email that Mr. Lineberry sends that she's on, along with a CC of hundreds of people. She copies them and pastes them into a new email, thinking that they're all parents, and she puts the public information on that, sends it out to the entire school, thinks she's sending it to the other parents. A mere 8 days later, the Miami Unified School District comes up with a parent contact management plan. Now, the parent, I'm going to call it the PCM. The PCM mentions various reasons why the plan was put into place, but they don't mention her posting public information about their principal in the plan. However, Mr. Lineberry wrote an email, and he implies in the email that it was done in response to my client posting the public information. See the iceberg starting to come out of that water? Now, to comply with the PCM, my client had a civil attorney, because she sees this and she's like, oh, this is shocking to me. She got 4 kids, 2 of them already graduated from Miami Unified School, no problem. She's got 2 currently in the school. Contacts an attorney, what can I do about this? The attorney advises her, well, this isn't an outright ban, so it's legal. What you need to do to comply with it, send 1 email a week on Sundays. Say you want to attend any events during that week.
This is getting into hearsay for a party that is not going to be testifying today.
Judge, this is what my client is going to testify to.
She can't testify to what somebody else told her.
I'm going to overrule the objection.
All right.
So that's what she does. She follows her attorney's advice. She'll tell you that. Like I said, don't take my word for it. She'll tell you that. She sends an email every Sunday, says some blanket statement, very polite. I would like to attend any event my children have on campus this week. For 8 to 9 weeks, there's no issues. Dr. Dorathy, she's the superintendent. GLEN LINEBERRY, he's the principal. They receive the emails. They routinely approve her. They respond with an email and say, hey, you're approved. Come to that event. Comply with the 48-hour notice requirement of the PCM. You're welcome to attend. Suddenly, after about 9 weeks, Mr. Lineberry determines he wants an individual email for every specific event she wants to attend. She feels he's changing the parent contact management plan without amending it. Now, Michelle Pettitt's the mother of 4. 2 minor children in 2021, both of Miami Unified School Districts. She's also a wife managing a home, and she's a doctor with a busy medical practice. That's 1 email per child, per event, per every day of the week. She cannot possibly manage sending emails 48 hours in advance for each child, for each event, without missing any events. She didn't want to miss any events because she missed all these events when she was in medical school. Now, how is she going to comply with this? Her IT guy at work had already told her about Boomerang. That's how she sent the reoccurring emails every Sunday. How can I do these future ones? So her husband and her sit down and they get every calendar they can find. The Miami Unified high school calendar, events calendar, the sports calendar, the club calendar, and they calendar every event that they can find, just in case she wants to attend, because she cannot manage sending all this out 48 hours in advance. They program all of those emails around late October, early November 2021. She never touches Boomerang again. She sets it, she forgets it. She's also not CC'd on the emails that are sent out from Boomerang. So she didn't even know the emails were going out unless GLEN LINEBERRY or Dr. Dorathy replied to her, granting her request to attend the school event. This goes on for 8 to 9 months. Needless to say, this caused a lot of emails to go out during the school year. She's sending the one on Sundays per her attorney's advice. She's sending one on Monday, Tuesday, and Wednesday, which is 48 hours notice for events on Thursday, Friday, and Saturday. And that's when most school sporting events are, Thursdays, Fridays, and Saturdays. 48 hours notice means you got to send it out at least 2 days in advance. What she didn't know is that she lives in Arizona, we're on Mountain Standard Time. The testimony will be that Boomerang defaults to something called UTC time, and she didn't know that. So the emails are actually sending out 7 hours before where they're programmed for. We're going to show you the Boomerang logs, and it's going to say the Mountain Standard Time when it was actually programmed to send out. This goes on for 8 to 9 months, and the school never amends the plan. During these 8 to 9 months, they continue to approve her request to attend events. Now, like Ms. Evans said, one of her children graduates in May of 2022, which leaves her with one child in the school district. After the child graduates, the school's not responding to the emails. She doesn't know that they're going out. Suddenly on June 30th, 2022, she's served with the injunction. After the injunction, the emails that were programmed 9 to 10 months ago in the fall of 2021 go out. One goes out July 3rd, one goes out July 4th, and one goes out July 5th. Deputy Wingate shows up at her work July 6th. He asked her, can you just delete the Boomerang app? She does. No more emails. Now, ladies and gentlemen, the evidence in this case show that at all times, Michelle Pettitt acted to comply with her understanding of the Parent Contact Management Plan, her busy schedule, and never to miss her children's school events, and that the emails, they were automated, but they were not specifically sent to harass GLEN LINEBERRY. Now, the question you're going to have to answer at the end of this trial is whether Michelle Pettitt knowingly harassed GLEN LINEBERRY after June 30th, 2022. And if the answer to that question is no, and it should be once you've listened to all of the evidence, you must return a verdict of not guilty. Now, during this case, I'm going to ask you to do 3 things, and only 3 things. First thing I'm going to ask you to do is to listen to all the evidence before you make your decision. Can you do that for me? I'm going to trust you to do that. The second thing I'm going to ask you to do is a little more difficult, to keep an open mind. Now, what do I mean by that? I mean that you, as individuals, each one of you, determine the weight or the credibility of the testimony you hear. You're not to believe one witness more than another because they're a police officer or because they're a school employee or because they're an alleged victim of a crime. You determine their credibility and how much weight you give it. And finally, the last thing I'm going to ask you to do, once you've listened to all the evidence and kept an open mind, I'm going to ask you to return a verdict of not guilty. Thank you.
Sure. I'm trying to find a place where everybody can see.
Ms. Evans, you may call your first witness.
Dick Olson stands, former principal of GLEN LINEBERRY.
Okay. Mr. Lineberry, if you want to make your way up front, right when you probably get here in the middle, I'll have you stop and the clerk will swear you in. So if you stop right there, raise your right hand.
Do solemnly swear the testimony about him will be the truth, the whole truth, and nothing but the truth, so help you God.
If you can go ahead and have a seat there, watch there's a step going up. Gene, can you move the microphone so it's on his left side, so he's looking towards the jury or Ms. Evans, he's sort of in line. And Madam Clerk, I'm going to ask him to state his name for the record and then make sure he's picking up. So if you could check. I'll ask you to be pretty close to the microphone, sir, so pull it close. We're recording everything, so it may not come through the overhead, but it is recorded. Can you tell us your name?
My name is GLEN LINEBERRY.
Okay, Ms. Evans.
Good afternoon. Thank you for being patient with us. So, first I want to talk about your education experience. Can you give me a rundown of your education experience?
I hold a bachelor's degree in economics, master's degree in secondary teaching and curriculum, and a doctorate in education leadership.
All right. So, at some point you worked for the Miami School District.
From 2014 to 2023.
All right, that was my next question. All right, so what did you do in your role there? What were your responsibilities?
I was the principal and CTE director, which is career and technical education. A lot of us do is vocational education. For the junior, senior high school. So I had, depending on the year, either 7th through 12th graders or 6th through 12th graders. And I was the administrator for the building, so I was responsible for the facilities, for the safety of the students and the staff, for student life, which certainly means discipline, but also includes athletics and extracurriculars and all those sorts of things. And then for the academic program, for the curriculum, for the courses, for hiring and training and monitoring and evaluating teachers. So if it happened on the campus, it was pretty much my responsibility.
And why were you brought in to be the principal of Miami High School?
They had let the previous one go.
Why did they let him go?
Well, I wasn't there, for starters, but what I understand, there were severe disciplinary issues. There was a fairly significant drop problem on campus. Teachers weren't teaching in areas that they were formally qualified to teach in. And there was just a general sense, and there had been a lot of turnover. I was the 9th principal in 18 years.
And were they hoping that you would come in and kind of help resolve these problems?
Yes.
So you said that at some point you retired? Yes.
I did. I retired in summer of 2023.
Well, why did you retire?
Partly because I was tired. COVID sort of took it out of a lot of us. Partly because in order to fill instruction gaps, it's hard to find enough teachers, especially in rural schools. Several of us had formed a network to fill those gaps, and that was growing, and so I now run that on a full-time basis.
Did you move out of state?
Yes, I'm living in Jacksonville.
And was that to try to help fulfill fill a gap there? Or for
Jacksonville?
Yes.
No, my wife's family are there, and we were from here. We both grew up. My wife's family's there. I grew up in the South, and we want to be close to the ocean.
Oh, is it a beautiful view?
We don't have quite that much money, but it's not enough to beach.
I don't think I have that much money either. All right, so what are you doing now that you've left the Miami School District?
Well, I run this thing called the Arizona Student Opportunity Collaborative. I have a couple of 3,000 kids taking courses from about 65 rural secondary schools across the state. And that's what I do.
All right. Do you like doing that?
Yes.
All right. So let's move on and talk a little bit more about the defendant and her family. So who is Michelle Pettitt?
From our standpoint, she was the mom of 2 boys in our school.
Who were those kids?
I don't know if I can use names.
We're going to use names. It's okay.
Okay. You're telling me I don't violate privacy laws?
No.
Okay. The 2 boys were named Justin Cook and Gavin Pettitt. Justin, when I got there, was probably 7th grade, or maybe not even in the school yet. I was his principal, I believe, this entire time in the junior senior high school. And then Gavin came along several years later and was there for, I believe, 6th, 7th, and 8th grade, certainly for 7th.
Did you know them very well?
I knew Justin really well because I also taught government and economics for all the seniors. And so I had them as students. And he was a pretty active member of the student body, and so I engaged with him on a lot of those activities. He was an excellent athlete. Gavin I saw less because he was in junior high and then transferred.
Did you have any issues with them?
Was the boys?
No. Oh. Did you like or dislike them?
Well, if your parents, you know, you try to, you love them all, but no, I like them. They're good kids.
All right, so let's get this out of the way. Do you see Michelle Pettitt in court today?
Yes.
Can you point her out and identify an article of clothing she's wearing?
She's seated over here in a black V-neck top.
May the record reflect that the witness has identified the defendant.
It will so reflect.
All right, and so I can get this out of the way. Is the Miami Unified School District within Gila County?
Yes, ma'am.
And is that where you would receive emails and any other kinds of communications?
Yes.
And did you also live here at the time?
I did.
All right. Okay, so without getting into any details, were there issues between Michelle Pettitt and the school district?
Occasionally, yes.
And did that eventually lead to the creation of a parent contact management plan?
Yes.
Now, I believe that you were sitting here for defense counsel's opening statement. Did you decide to do that because she posted information about you on Facebook?
No.
Did that matter to you at all? And in fact, you didn't put that into the reasons for the parent contact management plan? It was for all of those other reasons.
Yes.
So, what is a parent contact management plan?
There are times when parents and schools come in conflict. Sometimes it's because we've mishandled something, in which case we need to fix it. Usually, when there are conflicts, conversation, exchange of information solves a lot of it. And but every once in a while, you have a conflict that just doesn't seem to be manageable. And so a parent contact management plan is a way to lay out the rules to do two things: to guarantee the parents' rights under the law to access the information they need in order to manage their children's education, and to protect the school.
Had you ever written one before?
I did not.
So how did this parent contact management plan come into being?
Well, the school district has attorneys to the state trust, and so we consulted with them, and they ended up drafting it. I drafted a summary of events that they used, some of, and then they sent us a draft of that we edited, not for legal wording, but for correctness, to make sure that the correctness was accurate.
And then once it was completed, was this sent to the defendant?
It was signed and sent out to the superintendent, yes.
And the superintendent would be Dr. Sherry Dorathy?
Correct.
So was there a requirement that she notify the school of anything?
And Ms. Counsel, can you clarify who the she is?
The defendant.
Okay, because we had Dr. Dorathy there a moment ago.
It's been a while, so I'm not going to guarantee I remember all of this, but the parent contact management plan clearly stated that this was to protect her rights as well as protect the school. And it limited her contact with the school staff to the superintendent and to me. And it required her to request permission 40 hours ahead if she would currently exercise. And
Did you expect an individual email for each event she intended to attend?
I don't recall that I had an expectation at the beginning. There aren't that many events. Justin was involved in sports, so there would have been 6 or 7 home football games a year. And he was involved in some other things, but we didn't anticipate being that many events.
Okay.
So we probably did expect that.
Okay. And did you expect her to send an individual email per child, or just one if she intended both children?
If she had sent an email that said, I'd like to come to Justin's football game and Gavin's band concert, it would have been both.
Did you ever deny her access to the school?
No.
How did she react to getting this parent contact management plan?
I believe that she phoned the superintendent, and I think she posted some things on Facebook.
Okay. And was this completed about August of 2021?
That sounds right. Yes.
All right. And so because she posted about it on Facebook and called the superintendent, you knew she had it?
Yes.
So at some point, did you get a single email saying she was going to attend all events?
I believe so.
Would that have complied with the plan?
No.
Why not?
Because the plan called for a request.
So when she sent that email, what was your response?
I'm sure you have it. I would have written back and said that we need more specific requests. And I would have consulted the superintendent, and she would have consulted the attorneys before we said that.
And why is that? Why is the single email not enough?
Because it doesn't, what would it mean? I mean, for starters, not every event at the school that students attend is open to parents. Just to begin with, I guess is the first thing that comes to mind. And if we gave, and the idea was to make certain that she could still attend anything that her kids were participating in. But that doesn't mean every school event.
So, at some point, was there a cease and desist letter telling her that she wasn't in compliance?
Yes.
And did it say that she needed to send out an individual email for each event?
Again, we're talking several years ago, but I believe so.
Okay. So, after she got that letter, what happened?
Then we began getting more emails. As I recall, there were a few that were very specific. But then we were getting a lot of emails that were for events that didn't exist. I want to come to the game this week and the game was away, or something like that. And so at some point, we just pulled up a list of, emails and complimented the fact that they were at the same times, in the middle of the night, on the same days of the week. And then when we compared them, they were identical. Identical wording, identical punctuation, identical capitalization. So it's obvious there was something being copied.
So let me ask about something you said a little bit earlier. She would ask to attend games that were away. Did she have to ask for permission to attend away games?
No. And she also asked permission to attend games that just weren't any.
So it was only on games that were happening on the Miami School District.
Yeah, our authority doesn't run beyond our school.
So if there's half of the games away and half of the games home, then she would only have to send out half the emails. How many emails did you start getting?
So they were coming 3 or 4 nights a week in the middle of the night. So, I'm not saying it's exactly this, but maybe Monday morning at 1:05, and Tuesday morning at 12:45, and Wednesday morning at 4 a.m. That sort of thing.
Did that create any problems with you that they were coming in the middle of the night?
It did. I'm the guy that called when something happened. So the school bus breaks down bringing the basketball team home from the away game. The intrusion alarm goes off at the high school, or a fire alarm, or any of that sort of thing. It's essentially you call. A kid is involved in a car wreck and is hurt, something like that. So I left my phone on next to that. And so text it, email, the phone call comes in, and the phone rings.
At any time, did you start feeling harassed?
Yeah. At the point that we realized it was on edge.
Was there ever any time she asked to attend an event more than once, even after she was given permission?
As I recall, it was something like 12.5 requests to attend Justin's graduation. And that came after we had already told her that she could attend.
So at some point, did you contact your attorneys and ask them to send another cease and desist letter?
I believe there was a second letter, yes.
And did that letter ask her to stop with the numerous emails? Did it ask her to stop with the automated emails?
I believe it did, yes. Yes.
And was she informed that the number of emails was problematic?
Yes.
Did she acknowledge that she knew that?
You mean by in correspondence?
Yes.
Yes, there was an email where she said that she knew it was burdensome and unpleasant, something like that. I don't know exactly, but yes, it was clear that she understood that.
And was that done in an email about May 22nd?
Sounds right.
Okay. All right, let's see if I can work this. I apologize in advance. We're using a new system to introduce evidence. I'm still learning how to use it. All right.
And Ms. Evans, are you going to ask him to look at a particular document?
Yes.
Then I think he can just do it right on his screen.
Yes.
So what document would you like him to look at?
I need
Jean,
number 33.
Jean, can you take a look at this and see if you can make sure it's pulled up? No, that one I believe is freestanding, isn't it? That's not going to reflect what's on her screen.
Okay, I have pushed the buttons I've been told to push.
Okay. 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 Looks like there's something on his screen.
Can I show it to lawyers? Lawyers, okay. Okay, so I have shown...
Just a second,
oh,
you need to mute that. Okay.
I didn't realize that was going to be. All right, I have shown the witness what has been marked as State's Exhibit number 33. Do you recognize this document?
Yes, it's an email from Mrs. Pettitt on May 10, 2022.
May 10 of 2022. Thank you. Is this the email that you received from her?
Yes.
Is it a fair and accurate representation of the email that you received?
Yes.
And this is from the same Dr. Ann Pettitt email that you got all her other emails from?
Correct.
And what is the time on this email?
8:48 p.m.
All right. Your Honor, the state moves to admit exhibit number 33.
Any additional objections, Mr.?
No, you're not.
Okay. 33 is admitted.
So, at this point, the state would ask that we be allowed to show the jury.
Okay. You may. Members, Jean, do you know why is that TV going to be on or not? I'm not familiar with how we're using it. Okay. Members of the jury, any exhibits that are admitted may be shown to you in court. When you retire back to the jury room to deliberate, you'll have access to them. And so you'll have as much time or as little time as you choose to review those documents. Okay? So again, if an exhibit's admitted, the attorneys show it to you, if you raise your hand and say, I want to look longer, I'm going to say, not right now, but when you get to the jury room, anything that's admitted, you'll have as much time as you need. Okay? Okay.
Oh, presentation mode is not.
Kayla, are we just using just these two screens, or will that one work too? Okay.
All right.
Okay, hold on just a moment. Kayla's going to also put it on the upper screen, or the other screen. I suspect many of our jurors, like that may be too far for them. Let's see if that comes on.
Are you still able to view this, Mr. Lineberry?
Yes.
Okay.
Let's see if that's coming on. Oh, there we go. Okay. And Jean, can you pull that out just a little bit? We'll have to move it before our jurors leave so they don't hit their head, but I want to make sure if they choose to look at that one, they can. Okay. Okay.
So, let's make this a little easier. Mr. Lineberry, would you mind reading the entirety of the email?
The entirety?
Yes.
I'm sorry that the emails have become time-consuming and bothersome, but I'll remind you that complying with the parent contact management plan that you yourself approved. I'll also remind you that the parent contact management plan was based on accusations that are completely made up by Mr. Lineberry, who I'll also remind you has an extensive history of lying, cheating, and stealing. I will also remind you that I've had to answer daily emails from Lineberry for nearly 2 years, until recently, when I'm assuming his counsel advised him to stop. With that being said, I considered letting it all go after the last email where you were generous enough to give me information regarding my son's graduation and ceremony times. But then I remembered that you could have stopped this before and any time during this pointless and unreasonable ban. So here's how this is going to go. The emails will be sent automatically for any game of any sport for any grade and any event taking place on Miami Unified properties, just in case I want to attend. The demands of the parent contact management plan, I'm sorry this keeps...
Oh, yeah.
would otherwise be impossible to comply with. The emails will continue to send until my children graduate, the ban is lifted, or the World Wide Web crashes. But again, I'll remind you that I'm complying with the rules set forth in the plan by no one other than you.
So at this point, she's aware that there's a problem with the number of emails.
Yes.
And this was on May 10th of 2022.
Yes.
And she's discussing how she had information on her son's graduation.
Yes.
And when do school events stop at Miami Unified School District?
Graduation is the Friday before Memorial Day, so there are no school activities after the end of May.
So, By May 10th, there would have only been about a handful of events.
Right. If Justin was, if this is the year Justin was graduating, then there would be several senior events.
All right. So, and then after you got that email, did the emails keep coming?
Yes. Yes, the emails continued into the summer.
Were there more emails than events?
There were, and there were emails past the end of school, including the emails for Justin past his graduation.
So, what did you do after that?
Well, at this time, the lawyers were in the driver's seat. So the attorneys the school attorneys went to court for an injunction against harassment.
All right. So, let's bring that. I'm showing the witness what has been marked as State's Exhibit 3.
I believe it'll be on your screen there, sir.
As soon as it loads. My internet is running like internet in Globe does.
Okay, I believe I have it now.
Wait. Okay. And do you see the certification page?
No, it disappeared.
Can you see it now?
No.
Let's give it a minute, maybe it's just loading. Anything?
Yes.
It's not loading now.
It's loading. I don't see the text yet. Here it is.
All right, technology's working. All right. In order to speed things along, this is a certified document. It is self-authenticating, so I move to data exhibit number 3.
Any objection to 3? Okay. Petitioner's Exhibit 3 is admitted.
May I show the jury?
Yes.
And when was this injunction filed? I believe it's in the top corner.
Stamp says June 28, 2022.
All right. So that would have been the date that you received the injunction.
Well, I didn't receive it.
Or
I
that-
just filed it. Right.
Now, it looks like there are some specific requirements on this injunction.
Yes.
Did one of those instructions include no automated emails?
Yes.
And did another one include do not send them in the middle of the night?
Email during business hours only except in emergency.
And why are those specific requirements there?
Because we were being wakened every night by emails. And this is a month after school, so, a month after Justin would graduated.
And you're still getting emails?
Yes.
And was this served to the defendant on June 30th, 2022? I don't know if it's on this document, but I can show you another.
I don't think I don't have, that's not on this, what I see.
Is defense willing to stipulate to that?
Are you asking for Exhibit 4 or just a date?
Just the date, so I don't have to introduce the service.
Oh, okay.
Yes.
Okay. So I'll put on the record, counsel, there's no objection to the stipulation that the defendant was served with Exhibit 3 on, I'm sorry, what day, June
30th, 2022.
30th, 2022. Madam Clerk, if you could note that in the minute entry, and members of the jury, I advised you in your opening instructions about stipulations.
Was there another way that you knew that she got it?
I believe there was a social media post.
So on Facebook?
Yes.
Did she make a specific comment about it?
That she, I don't remember the exact wording, she couldn't be silenced, she would have to say something like that.
Does the phrase, and while at the moment they can prohibit me from emailing, mailing, they cannot shut me up, sound familiar?
Yes.
All right. Did you get another email after that? After she received the injunction?
Yes, we got 3 or 4 more.
Okay. Back to evidence. This clock's working? I don't know if that's going to affect it. Does it? No? Oh, okay.
What exhibit are you trying to show?
13.
Okay, has it been admitted yet?
Not yet.
Okay, then we just need to make, you're trying to show it to the witness.
Yes, I'm going to try to show it to the witness.
Okay, I have,
You have it. Do you recognize this document?
this is an email to me from Ms. Pettitt, to me and to Dr. Dorathy, from Sunday, July 3rd, 2022 at 12:01 a.m.
All right. And what does it say?
I am requesting to attend any event that Gavin and/or Justin may be participating in this week on MUSD property.
And that would have been on Sunday?
Yes, ma'am, Sunday morning at 12:01.
And that's from the same Dr. M. Pettitt Gmail address?
It is.
Yeah. And is this a fair and accurate representation of the email that you received that early morning?
Yes.
All right. State moves to admit Exhibit 13.
Objection.
13 is admitted. Petitioner's 13.
I think, though, that I won't be able to present it to the jury. I think that's the issue. I move to show it to the jury.
No issue. I do so.
Was this a pretty typical email that you were getting?
Yes.
All right. So at this time, was school out?
Yes, this is the day before. This is July 4th weekend.
Were there any events happening at the school or on school grounds that week?
No.
Was there any reason to ask to attend anything?
No.
And was this similar to the other emails that you got asking to attend non-existing events?
It was.
And again, this was after that main email where she knew these emails were problems.
Yes.
All right. So, moving on to number 14.
I have it.
Do you recognize this document?
Yes, it's an email from Ms. Pettitt to Dr. Dorathy and me, dated Monday, July 4th, 2022 at 4 a.m.
4 a.m. And that's a different time than the previous email?
It is.
Was this in a same or substantially the same condition as when you first saw it?
Yes, you blacked out our email addresses.
State moves to admit exhibit number 14.
Objection.
14 is admitted.
I'd like to show the jury.
You may publish.
What does this email say?
I am requesting to attend the game Wednesday.
Was there a game Wednesday?
No.
In fact, this is the 4th of July?
Yes.
All right. Is this also pretty typical of what she would send?
Yes.
It's not specific?
Correct.
I'm showing the witness what has been marked as exhibit 15.
I have it.
Do you recognize this email?
I do. It's an email from Mrs. Pettitt to Dr. Dorathy and to me, dated Tuesday, July 5th, 2022 at 1 a.m.
A third time.
Yes.
All right. State moves to admit exhibit number 15.
No objection.
15 submitted.
Like to show the jury?
Yes.
What does this email say?
I am requesting to attend the game on Monday.
All right. Was there a game the next week?
No.
Were there any events going on at the school that week?
No.
Was there any reason to send this email?
No.
Was this also very typical of the other emails she would send?
It was.
Ms. Evans, before you go further, I think we're going to take a stretch break. We're not going to take a break, but I need to stand up. It's been a while since we had a lunch. So members of the jury, if you'd like to stand up with me as well, you're free to. Mr. Lineberry, you're free to. Counsel, I just want to make sure we stretch. Sometimes after lunch, first thing, it's a little difficult. So we can stretch.
That's fine, Your Honor. Actually, if we could take a quick break, there is an exhibit that I want to admit that
Let's go ahead and do this. We're just going to turn this into a regular break.
Mhm.
It is, I'm going to sit down so I'm close to a microphone. It's now 1:45. I'm going to plan on the attorneys, hopefully, and I can resolve whatever matter we have in 5 minutes, and then I need to give my staff 15 minutes. So if you could be ready to come back at 3:05. I'll excuse our jurors. Please remember the admonition. You can't even discuss the case amongst yourselves. No research, please. I'll excuse our jurors. And Mr. Lineberry, you can step down then at 2:20 or 3:20, excuse me, if you could just come back. Okay, please be seated, counsel. I'll note the absence of our jurors. Counsel, I'll note that several of our jurors were having droopy eyelids, and I wanted to make sure that we weren't losing them. Ms. Evans, you had an issue you wanted to raise with the courts?
Yes, I got an exhibit from defense counsel. It's the spring athletic schedule.
Okay.
And unfortunately, case time is closed before I can put it in. I can't. Huh? I know, but I can't case time before. That's my issue.
Yes, you
I
can.
can't get your exhibits.
Yes, you can. Just click on them. It should open.
Well, I can't get to the exhibits. All I can see are mine. That's the issue.
Click on the where it says defense exhibits, and then it'll
I don't
open.
have it.
Okay. You should have access to it. Do you want to stipulate to the admission of defense 12? Or is that what you wanted to admit it, correct?
Yes.
And you've marked it.
I'd like
Okay.
to show him, promise I don't have to present it.
Okay. We'll make sure we get someone here. No, well, we'll get somebody back. Kaylin, Ms. Evans is indicating she can't view the defense exhibits. Can you take a look at her tablet and see what the issue is there? Okay. Madam Clerk, I am going to order that defendant 12 is admitted by stipulation. And counsel, I will let the jury know that when they come back, and then either of you will be able to display it.
For some reason I can't, I don't know.
Yoli's here too. We have the full team.
Yeah, she's gonna get that.
I'm usually okay with text.
Okay.
But case time does not do it.
Mr. Cloud, I think you had asked to potentially open up and upload a new exhibit.
Yeah, I don't think it's one that can be published to the jury, but I want to be able to use it for impeachment for the witness.
I told the clerk at the break to go ahead and open that up for you so you can upload it. Please make sure Ms. Evans, if she doesn't already have a copy, has a copy. By uploading it, it's just like having put a number on it. So.
There's also going to be a short recording that I may need to impeach him. Maybe to impeach with, and that's something I would need him through the headphones, kind of verify to him that he said it, and he might think that would help.
And it looks like Kaylin has those.
Other than I wanted to bring up testimony on.
Okay, we'll do it in a break in just a minute.
That 8189 being hearsay, I think that is 8035 is recorded recollection prepared for Ms. Evans, the summary for trial.
Okay, let's let Ms. Evans deal with the issue and then.
Also, I think
No, just
close out the exhibit list. comes, like, so this is the middle, it has a list of you do this on the left, and you hit that X for you publish.
Well, if we actually, Mr. Cloud would like to push buttons one.
Okay, do we think that tablet is just doing?
No, it's because I'm signed in under my assistant's login, so it's not letting us see the other, the ethics assistant.
Is that something we have to go through case lines to get that access, or who gives that access?
No, there's no shared under one.
Your login is not working?
Yeah.
And it could be, depends on how her account was set up, to decide what access she has, whether it shows.
Okay, so can you change the access then? Who changes the access?
She would probably have to change it when she.
Who's she?
She's able to log in on her laptop and not on
When
the tablet.
she creates her account, it depends on if she puts in legal clerk or assistant or attorney.
Right.
So if she puts in attorney, she'll have all the access, but Ms. Evans will have it. If she puts in legal clerk, she's
Right.
Okay,
I could sign in under mine.
okay, let's try that.
What, if you want to do that, or we'll just, for today, have your laptop and get something moving.
In this paper.
It is.
Yeah, I was just talking over here and grabbing it. Makes me more active. It's my system. Yeah, so this way I want to upload like everything just in case, and then I get like 40 exhibits and we use 4.
But that's not, if we did it with paper, we'd do the same thing. You'd
Yeah.
get them all marked, so.
No, this is, I don't have to log into it.
Okay, no, Mr. Cloud wanted to upload additional. Ms. Evans, with 12 being admitted, you don't have it, you don't need to upload any
No.
additional.
I see that.
Okay. Is there anything we need to address then before we break? I don't think so.
Oh, wait. That page 180,
What number is it?
Maybe that's the Mr. Liner's email.
yeah, Mr. Liner's email.
Recorded recollection.
But the ruling was that it was hearsay, and not this, I'm not saying I wanted to do this and did it, but I dispute the fact that it's automatic hearsay. He used the exception under recorded recollection. It was prepared in preparation as a summary of everything for trial.
And let's see here. So is on a matter the witness once knew about but cannot accurately recall, are you under subsection 8035?
Yes, so if I establish that he can't recall it, he won't agree with it, then I'll show it to him.
It is hearsay. 8035 is an exception to the hearsay. So if we get to that point and you want to re-urge it under that exception and you've met the requirements, I'll reconsider that. Okay.
I would still object to the direct admission of the document because even when I use a police report to record a recollection, they can use it to record to refresh their recollection, but not actually in the document itself.
And we can all take a look at 805 at the break. There's different rules for DRs. 805 or 8035, it indicates if admitted, the record may be read into evidence, but may be received as an exhibit only if offered by an adverse party. So it seems like if I rule that it is under 8035, Mr. Cloud would be an adverse party. Therefore, theoretically, it could come in if we get there. Okay. Okay. Then we will. What time did I tell them that? 3:05, right? Okay, counsel. I'll see you back at 3:05 then.
Thank you. Okay, position to make a medical lawyer on that.
Okay, we'll return to the record in State versus Pettitt, CR 2022-425. I'll note the presence of counsel, defendant, our jurors. Members of the jury, thank you for your patience. We're just trying to fight some technology issues. I will let the jury know that during the break, there was a stipulation and defendant's exhibit 12 has been admitted into evidence. And so the attorneys may show you at some point during their presentation. If not, you'll have access to that when you get to the jury room. So you can note Defendant's Exhibit 12 has been admitted.
Permission to show the jury, Your Honor?
Yes, and Ms. Evans, you may continue your direct, and you're now publishing Exhibit 12.
Do you recognize this document, Mr. Lineberry?
It's not appearing online.
I do.
It's a spring athletic schedule from the spring of 2022. It's the baseball, softball, tennis, and maybe track.
So if I go down.
And golf.
Oh, there's some more here.
So that page, top page, it's a junior high schedule, the bottom page is the high school schedule.
Okay, so will this contain all of the scheduled school events at the school?
It would contain all of the scheduled athletic events at the school.
Okay, so all the scheduled athletic events.
Yes.
Quick question, was Justin involved in sports that year, or during that time?
I'm open to correction, but I don't believe he played baseball. I don't believe he was in a spring sport this senior year.
All right, so taking a look at that, does it appear that the first sporting event would have started on about February 23rd?
Yes.
All right. And then going down, and if you need me to move this anywhere, let me know. It looks like the last event would have occurred around May 14th, at least the last sporting event.
That sounds about right.
All right. And all told, if we combine all events together for all the dates, is that roughly around 50 days?
Well, it's around 50 days for the entire school, yes.
Okay. Do you have more emails than that?
Probably so. And those 50 days would include softball, which is on the girls,
And do these dates include away games?
they do.
So probably less than 50 events at the school for sports.
Yes.
Okay. All right. Your Honor, I think that defense and I, and he can correct me if I'm wrong, but we have a stipulation to the admission of the boomerang email logs.
And what exhibit number is
That would be D12, D6, that would be the redacted copy.
Okay, Mr. Cloud, is that correct?
That's correct.
Madam Clerk, by stipulation, I'll order that D6 be admitted into evidence.
Permission to show the jury?
Yes.
Okay.
And you'll need to change up your screen there.
The first one's okay.
Kayla, should that be showing on this tablet or not?
Unless they present it to them.
Okay.
She doesn't have presenting.
All right, click the button. Still hiccups. All right. So, at the start of this document, the first email, what was the date that it was sent?
I'm sorry, can you repeat the question?
So that very first email at the top of the first page, what is the date and time?
February 2nd of 2022.
Okay, and is that stating at 8 a.m.?
Yes.
Now, did you ever get any emails at 8 a.m.?
Not that I recall.
So were you in here when defense counsel noted that some of this was in something called universal time?
Yes.
Okay. So, now comparing this with the sports schedule, would this have been at least 2 to 3 weeks prior to even the first sporting event for spring?
Yes.
If you do a quick count for me as to how many emails are on this page. Can you move it on your screen?
It's not appearing on my screen, it says offline.
Okay. So how about we count together while I scroll? So 1, 2 for the February 6th, 3 February 7th, 4 February 8th, 5 February 9th, 6 February 13th, 7 February 14th, 8 February 15th. I cannot move it down anymore. believe we are lagging. Oop. Okay, so, were we on 8 February 15th?
Yes.
9 February 16th, 10 February 20th, 11 February 21st, 12 February 22nd. So, if you don't mind, now we'll count the number of pages. 1, here we go, it's right there. 12 pages with around 12 emails apiece. Does that sound about right?
Yes.
So we're going to get to over 100 emails. All right, so I'm going to scroll down some more. And we noted that on about May 10th is when she sent that email thanking them for giving her information on her son's graduation.
Correct.
All right, let's get down to there. Okay, so do you see something on there that says May 8th, 2022 at 12 o'clock?
I do.
And does it say requesting to attend graduation?
Correct.
So that would have been shortly before that May 10th email?
Yes.
And would she have gotten permission to attend at that time?
I'm guessing either in response to that email or to the one I got down from May 9th, yes.
Okay, so let's count how many requests to attend there were. So after that, 1, 2, and let's take a look at those times. Do we have 12:01 and 12?
We do.
Do those appear to be automated?
I'm sorry, I didn't understand the question.
Sorry, do those appear to be sent automated?
Yes.
Okay. So what are we at, 2?
2.
3,
6.
4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19. All right, that looks like it. So 19 emails requesting to attend graduation. So what's the date of the last request to attend graduation?
May 27th.
So a full 17 days after she got her permission to attend.
Correct.
And does it look like most of these were sent at around the same time?
Within a second or 2, yes.
All right. So, getting back to those, which one was that? Designated, so we'll let the jury review the rest. So, what happened after you got those final 3 emails in July?
Well, as I said earlier, by this time the lawyers were handling things. So I had been instructed to forward the emails to the attorneys if we received them. They assumed we wouldn't, but we did, and so I forwarded them to the attorneys.
And what did they do in response?
I think they notified the court that it issued the injunction.
And at some point, were you contacted by, or did Deputy Wingate get involved?
As I understand, I never had contact with the deputy.
Did you inform your attorneys that you felt harassed?
That had been a conversation for almost a year at this point.
And in response, is it your understanding that they contacted Deputy Wingate?
Yes, it's my understanding that the attorneys notified the sheriff's office.
And after they got involved, did you get more emails?
I don't believe so.
So finally, they stopped.
Yes.
Nothing more for this witness, Your Honor.
Mr. Cloud?
Do you need either of this?
No.
Hello, sir. How was your trip?
Is that right?
All right. Was it snowing in your part of Florida?
No.
No?
You guys can tell me.
And Ms. Evans, can you see or do you need Mr. Cloud to move over? I just want to make sure you can see.
I can see you.
Okay.
Thank you.
All right, Mr. Lineberry. In the 2021 to 22 school year, Michelle had 2 children attending Miami Unified School District.
Yes,
One was in 7th grade,
probably so, yes.
and one was a junior in high school.
In the 2021 school year or 21-22?
21 to 22.
I honestly don't know. I thought Justin graduated at 22.
So he would have been a senior. Okay. All right, and both of those children participated in school events,
Yes,
specifically football,
yes.
basketball,
I don't believe Justin played basketball that year. I don't know about that.
soccer,
No, I don't think so.
tennis. Do you remember of any clubs?
Justin was on student council. There aren't that many clubs in the junior high.
Okay. Were there other after-hour school events other than sports?
Occasionally, there would have been club meetings, school dances. As you get into graduation, there are several events for seniors, senior banquet, that sort of thing.
Okay. Is there an event nearly every day of the school year?
I'm sorry, say again?
Is there an event nearly every day of the school year?
No.
Is there 150 days in the school year?
146?
Now, you saw that calendar that was put up there. I believe it was Defense Exhibit 6. Did it say in the corner all dates and times of events are subject to change?
I didn't notice it, but it should.
Do you want me to show it to you real quick?
If you like, I'll accept it.
Okay, I think it's been admitted. Did sometimes events get canceled?
Sure.
Did sometimes events get rescheduled?
Yes.
Now, the Miami Unified School District put a parent contact management plan in place on August 25th, 2021. Is that the correct date? Okay. Now, that was put in place following Michelle's posting truthful information about you on Facebook. Isn't that true?
I believe so.
Okay.
I don't track Facebook, so.
Okay. But you were aware she posted it on Facebook, and it was all true, correct?
I haven't seen everything she posted.
From what you saw, was it all true?
No.
What was not true?
There were distortions, misrepresentations.
So the public records that she posted were not true?
The public records were true, and she wasn't supposed to,
And she also emailed that information out to people at school, correct?
including all of our students.
Okay. And she sent out truthful information.
Some of it was true, some of it was not.
Okay. But the part that she pulled from the public record was all accurate.
Yes,
Was that embarrassing to you?
somewhat, but it's not the first time somebody did it.
Was it the first time the parents of your students had been made aware of it?
No, it wasn't the first time a parent posted it.
Okay. Do you believe the parent contact management plan was put in place because she did that?
I believe it finally went in place because she emailed students.
Okay. Because she emailed students about public information that was embarrassing to you, correct?
Because she emailed minor students on their school email addresses that were supposed to be for school business.
Okay. And the content of the email was it?
We're getting really, really close to rulings that have already been made.
I haven't disclosed anything, Judge.
If there is a objection, Ms. Evans, I'll address it when it's made. But I don't think, if you have an objection right now or not.
I will object, Your Honor. There are prior rulings, and he is getting awfully close.
Okay. I'll overrule the objection with what the questions have been asked as of now.
Mr. Lineberry, is that incident reflected in the reasons listed in the parent contact plan?
As I recall, the parent contract plan, yes, the contract plan specifically restricts her to emailing only Dr. Dorathy or me.
Okay. You just told us that the plan went into place after she posted public information about you. Is that incident reflected in the parent contact management plan?
I think we took any official notice of the social media posts, the email.
Do you know how she got the emails that she sent it to?
I did.
How do you believe she got it?
Because during COVID, we were sending emails out all the time, and we were uninformed as to email security. So we tended to just send emails out.
So it was
We even had, Dr. Dorathy and I had a conversation about the ECC on email, and we're old enough that that was something that some people put on emails, on memos, on tender memos that they didn't share.
So you were sending out emails with CCs and not BCCs, correct?
To be honest, they may have been in the 2 column.
Okay. And so all she did was take an email that you sent out to the public, copied the email addresses because she was on it, and put it in a new email.
Well, not to the public. These were only to our parents and to our students.
Okay. But she was on the email.
Yes,
So she didn't do anything nefarious to get that. You gave it to her.
correct.
Okay. She takes the public information, puts it in the new email, and sends it to that exact list.
I don't know if it was exactly the same list. That's what I read.
And the school district's response was to institute 8 days later the parent contact plan.
Well, and we did a course on email security and using ECC.
All right, now the parent contact management plan outlined restrictions on emailing school employees, correct?
I think it says school MUSD email addresses, but yes.
Right. Okay. She was allowed to email 2 people under the plan, right?
Correct.
You
Yes,
and Dr. Dorathy.
yes,
And she was the superintendent,
yes,
and you were the principal.
yes.
Okay. And the plan instructs you to request permission to attend events via email. That's true, right?
Yes.
It doesn't say specific events, it just says events.
I don't recall, I have to look at the documents.
Maybe we should look at it then. I'm going to show you what's been marked as defense exhibit. Pop up on the screen.
What number are you going with?
I am looking at defense exhibit number 11.
No, nothing is popped up yet.
Currently, no presentation is not available when the viewers are part of the case.
Do you know, Yoli, what that means?
It should come, you did start presentation.
Yes, I did.
He's offline.
And mine just popped up as an offline interest.
Was there an internet issue?
Switching to presenters on the
A second. Let's see if it comes up.
documents.
Did it come up now?
It's now fun, here's something. Okay, I'll briefly minute.
Can you tell us what that document is?
Just say it's loading again. Sir, why don't you just wait and let it load? See if it loads. Okay. And Mr. Cloud, will Mr. Cloud have control, or will the witness have control? So Mr. Cloud, if you, yeah.
I'm just
Hang on.
No, I can
Looks like he's going through it. Okay.
Okay, I have it now.
All right, so that is a copy of the school's parent contact management plan.
It is,
That's been signed by Dr. Sherry Dorathy.
yes.
All right, I'd like you to look at item D4 on the bottom of page 3, I believe. D4A.
Not page, the D here, not number, D4.
You can read 4A to yourself.
Okay.
Does anything in there say she has to identify which specific event she wants to go to in the emails to you?
This one is not.
Well, what do you mean this one? That's the parent contact management plan, isn't it?
This is the original parent contact.
And that's the one Dr. Dorathy signed.
Yes,
That's the one that went to Ms. Pettitt.
yes.
That's the one she's abiding by.
As I recall, when we.
Yes or no, sir? Is that the one that was sent to her?
It's the one that was the first one that was sent to her.
Is it dated August 25th, 2022? All right. So that's the one that she's operating of as of that date.
As of August, yes.
Okay. Does it tell her to identify specific sporting events that she wants to attend on MUSD grounds?
before the, 2 days before.
Yes or no, sir?
Yes, it does.
Where does it say that?
Request permission to attend via email to the principal and superintendent no later than noon 2 school days before the event.
Okay. Read the line before that. If you wish to attend a school event. It doesn't
It's
say.
going to be permitting portions of the PCM. I'm going to ask to include the entire PCM.
I'm going to overrule the objection. Mr. Cloud, yeah. So are you asking that it be admitted? Is that?
Yes, to
Okay.
complete the story.
Okay. And are you objecting to that?
Judge, I think we need to do a sidebar.
Okay. Counsel, you see the side.
She can have mine.
Members of the jury, I'm going to need to take a few minutes with our attorneys, so I'm going to excuse you back to the jury room. I'm hopeful that we'll have you back in 10 minutes, 5 to 10 minutes, so that gives you time for a cup of coffee, use the restroom, etc. So if you could just be ready for us. Please be seated, everyone. Mr. Lineberry, if you just want to wait where you're at. I'll note the absence of our jurors. I don't think there's, if you want to step down, I'm not going to have him leave the room. I think he's free to stay here. You can either stay here, sir, or sit in the back, whatever you'd like.
Would I step down?
I don't.
You can go. Would you prefer here or in the back? Okay. So, Mr. Cloud, my understanding is you're asking Mr. Lineberry to read one of the requirements under the parent communication plan.
That's correct, because I think we have a dispute as to what it actually says.
Okay. And I just want to be clear, you've had, on this document, you have not inquired into asking him to read the facts that give rise to the plan. I'm looking, the document has an A, which is the facts giving rise to the plan, B, the parental rights section, B is the policies, C is parental rights, D is the requirements of the plan.
Correct.
Okay. Ms. Evans, you've objected to Mr. Cloud going into the requirements of the plan. I had made previous rulings that we were not going to get into what led to the plan. I'm inclined to allow either party to get in what is required under the plan, but not get into what led to the plan, because I think the parameters that Dr. Pettitt was required to address any school officials is relevant to whether it would be harassing or not. So, Ms. Evans, you'd like to be heard on that?
Yes, Your Honor, although it sounds like you've already made up your mind. My concern is that the state agreed not to introduce the PCM because there's potentially harmful hearsay in it. And only to talk about this document generally, and it appears the defense agreed. Defense also asked not to introduce the PCM during its own motion in limine. Defense is now trying to use the PCM that I was blocked from introducing. So my request is, if he is going to introduce the document, that we introduce the entire document in order to complete the story.
Okay. Just a second. Mr. Cloud.
Rule of completeness, Your Honor.
Mr. Cloud, counsel, if there's no objection, I'd be inclined to admit the document, but with subsection A redacted, which is the facts that give rise to the plan. That's my concern, because once we start going, once we say, here's what led here, then we're going to be all the way back and we're going to be litigating what happened in 2007, which is not relevant. So, Mr. Cloud,
So, a couple of things. One, I think we're conflicting rulings that were made when I wasn't the attorney of record. I don't think we have stipulation today that the PCM wasn't coming in. You asked me if I plan on admitting it, and I said, I don't know yet. Probably not, but I don't know. But Ms. Evans just said, my motion in limine asked to exclude this document. I do not believe that's accurate. It asked to exclude the cease and desist order and the injunction against the petition. I've never said I'm not. When I came in this morning, I said, I want to tell the story, the entire story. We agreed to limit the lawsuit information to the words public information or public records, which I believe I complied with, though Ms. Evans did, I guess, object to me. But I didn't say what it was. I said I abided by the court's ruling. But if we're going to talk about the PCM, we have to talk about why it was put in place. That's what we're doing. Now we're talking about what were the actual restrictions. Mr. Lineberry read it, and he disagreed. Apparently, he reads it differently than me. That's what we're fighting about right now.
okay, so let me ask, counsel, I'm not going to, even if there was a stipulation, I don't think I would admit the entirety of the PCM, because I think once we get into Part A, then again, once we start there, and it's a matter of how far back I'm going to let it go, and I'm not going to do that. It seems appropriate, though, to either allow this line of questioning of this witness on what is the requirements and or to admit portions of it. So, Mr. Cloud, what is your preference? Do you just want to continue, or are you going to offer portions of it? Then I guess we'd probably need to have a redacted. The clerk can admit it by page, but she can't admit part of a page. So I think we'd have to do that.
I think it would be simpler and cleaner just to have them talk about the specific portions that Mr. Cloud wants to talk about, if we're going to do that.
Okay. And it seems like okay. So, Mr. Cloud, are you going to, I'm going to overrule the objection as to whether you can ask him about the language in subsection D. Mr. Cloud, if you go beyond subsection D, in fact, I'll tell you now, I'm going to preclude you from going beyond asking about anything that's not in subsection D. Subsection D is, I believe, what the school district said, here are the permitted uses. Am I correct on that? Counsel, I'm sure you've looked at this far more than I have.
So, subsection D starts with protecting school staff and students. The part that applies to my client is the exception.
Okay, so it's actually not even subsection D, it's just the part that starts exceptions.
It's the must. Yeah, the second half of page 93 and the top part of 94.
So I guess it's not D, it's just the exception section, which is not a separate section. So, Mr. Cloud, I will allow you to inquire about what is contained in the exception, from the exceptions down. Looks like there are 4. Let me just make sure that there's nothing beyond that.
Do I need to create an exhibit for this?
It seems that you can just inquire about this from Mr. Lineberry.
So here's my issue, though, because this is how we got that. He seems to think that this says you must send a specific email about a specific event. I don't think it says that. Well, how do we show that if he's not going to agree with me, I've got to impeach him? The way to impeach him is to read it into the record or show it to the jury.
And you can read it into the record. I don't think Ms. Evans is not agreeing with my ruling, but she's saying if I'm going to rule that way, you're saying most appropriate would be to ask her read it in. Is that correct, Ms. Evans?
Only the specific portions that he's discussing.
Right. So Mr. Cloud, I will allow you to do that. The exceptions portion will allow you to impeach and or read those into the record. Okay.
We still have the other issue about the audio recording. I don't know how.
Did we have any success with the audio recording? Do we have a way to let the witness listen to the audio recording?
And if this was a private meeting between Glen Lineberry and Michelle Pettitt, I still haven't heard it, and I still don't have access to it.
I do, right, can I play it for them?
I would object. I have no way of verifying this or rebutting it. It's the day of trial.
Just hold on, counsel, stop. Okay. Ms. Evans, I want to give you an opportunity to review what it is before, it may in fact be something you like, I don't know. So you're objecting, you don't even want a chance to review it?
No, because the disclosure is late.
Okay.
And it's the day of trial. Asking me to review it now and try to prepare for it, regardless of whether it's good for me or not?
Okay. Mr. Cloud, it sounds like the audio conversation that you're going to ask this witness to use at trial was not disclosed in advance. Do you have any documentation or information that it was?
If you want, I'll admit if there is. I will admit that I'm wrong.
I don't have any documentation if that it was disclosed, no.
Okay.
It was in the file I received from the attorneys though.
Okay.
But I think it's impeachment evidence, so it doesn't have to be admissible to be used for impeachment.
You're correct. It does not have to be admissible, but it still does have to be disclosed. And so I'm not going to allow you to utilize evidence either for impeachment or otherwise when it's disclosed during the first day of trial. Okay.
And for the record, I think that the only evidence that is disclosed to me from prior defense counsel was the boomerang email logs. Is that? Oh, yes,
I'm sorry. The only piece of evidence was the boomerang logs. You're
Yes.
saying there's no evidence, there's nothing about any prior recordings.
Correct.
Okay. Okay.
No, but
Okay. I've ruled on that. Mr. Cloud, anything else then before we bring in our jury?
No.
Okay. Let's, I guess we'll, is Gene back there with him, do you know? Okay, thank you.
Everything that I uploaded. She probably didn't know.
Please be seated, everyone. I'll note the presence of our jury, counsel, the defendant. Mr. Lineberry is still on the witness stand. Thank you, members of the jury, for allowing us to handle a couple of matters of business. Mr. Cloud, you may continue your cross.
Mr. Lineberry, do you still have the parent contact management plan in front of you?
Yes, sir.
All right, I'm at the bottom of page 4. We talked about it, 4A. What do you believe that says?
Well, I'm sorry, I'm an English teacher, right? So I think it says that if Mrs. Pettitt wanted to attend a school event, then before each of those events, she needs to request permission 2 days ahead.
Okay. Did you write that?
No. I was involved in conversations about it, and I sent with the language of this.
So that's your interpretation of what someone else wrote.
The difference of a school event and the event, yes.
Okay. Can you understand an interpretation that it says attend a school event is not the same thing as requesting permission to attend specific school events in the email that she sends?
Well, yes, because there are other items, sub-items under if she wishes to attend a school event.
Right. A is request permission to attend via email. It doesn't say send us an email for every specific event you want to attend. It says you want to attend an event in the school year, send us an email.
I think we're just going to disagree on this.
Okay. I think you're right. Does that mean that this is possibly open to interpretation?
You were in my English class, no.
Well, I wasn't in your English class. And we're still open to interpretation. Matter of fact, you ever heard of a movie called Cool Hand Luke? Yeah? Do you remember this famous line? Yes, exactly. My dad used to say this all the time. I was like, what are you talking about, Dad? That's from the 60s, right?
I saw it as a rerun.
Yeah? Okay. So, essentially, this parent contact management plan, what we have here is a failure to communicate.
That's what issues me. It's not a
Okay.
communication. It's failure to communicate.
What was wrong then? But you would agree with me. This is open interpretation.
I'm not agreeing with you. I think it's absolutely clear.
To you.
Yes.
I clearly, you've already said, I have a different reading of that. Right?
Right.
Is that fair?
I heard that there was a follow-on letter from the attorneys clarifying this at some point.
Okay. As this is written, is that open to interpretation in your mind or no? There's only one way that anyone can read this.
It seems clear to me.
And despite the fact it does not say email about a specific event, listing the type of event you want to go to. It doesn't, you agree that it doesn't say that though, right?
I agree it doesn't have specific.
Okay.
in it.
So
It says the event is specific.
you're asking it to be implied. It's implying send me an email per individual event, despite the fact it doesn't say that.
I don't think so. I think it's only like,
When you were testifying earlier, you testified that you received what you thought was an automated email, right? How long did you receive that automated email before you realized it was automated?
I think it was a while, because when we looked at the I said I pulled up the emails from her address, and there was quite a list of them.
Okay. So this was dated August 25th. Starting around that time, probably a little after, she started sending you a weekly email, right?
I think initially there was one weekly, and then we figured that it had to be specific, and then they started coming more than once a week.
So her interpretation was send the weekly email, which you approved for months, correct?
I don't recall.
You didn't, wait, let's stop right there. You didn't approve any of the automated emails that had the blanket statement.
We approved them until we couldn't tell what she was asking permission to accept.
Okay, so she sends this email out every Sunday like clockwork while her son's playing fall football, right? You're approving her to go to the games based on this blanket email, right?
Or writing back to say.
Do you have a trouble, wait a minute, sir, do you have a problem answering my questions?
Objection. Defense counsel is not allowing the witness to answer the question. He keeps interrupting her.
I'm going to overrule the objection. Mr. Lineberry, if there's a yes or no question, you'll need to answer it as a yes or no question.
Yes.
And so I'm not sure what the last question answer was, so Mr. Cloud, can you repeat the last question?
Okay. I'm going to clarify this. You agree, around late August, my client started sending you emails on Sundays.
I'll accept that they were on Sundays. I don't recall which day.
Okay? And that was kind of a blanket statement, correct?
Email for the week, yes.
Her son was playing football at that time, correct?
Correct.
See how easy this is? Doesn't have to be difficult. Now, was her generic or blanket statement email talking about, did it say something along the lines of, I'm requesting to attend any event that Gavin and or Justin may be participating in this week on MUSD property. Thank you, Dr. Pettitt.
I don't know. I know there were emails like that. I don't know if that's what they were in August.
If you don't know, I can show you. I'd like to show the Mr. Lineberry defense exhibit. That was 14. You let me know, sir, when you receive that. And you'll have to slow down to the bottom.
I have it.
What's the date of Miss Pettit's email?
I think this is a string.
Yeah, I'm going to ask you to go down to the bottom. Her first email.
Sunday, October 31st.
Okay. October 31st, she sends you a blanket email that says, I'm requesting to attend either of my son's events this week on school. That's what it says, right?
Yes.
All right. October 31st is over 2 months after the PCM went into place, correct?
Yes.
So her son was playing football in August of 2021, correct?
Yes.
Football season continues into September of 2021, right?
Yes.
And football season continues into October of 2021.
Yes.
And you approved her based on that type of email for 2 months, correct?
I don't know. I don't know.
You don't remember?
I don't know what the email said in August or September.
Okay. Do you recall approving her to go to any of her son's football?
Yes, we never denied her.
Okay. So she sent an email every Sunday. Would you have approved it?
I would have, or Dr. Dorathy would have, yes.
Okay. So for 8 weeks, she sent a blanket email. The school's approving them. She's going to football games. And then on the top of that email, you respond.
No, sir, I don't. The response is from Dr. Dorathy. I think.
Are you looking at the same email where it says from?
No, you're right. You're right. Yes, I responded on Monday, November 1st.
Okay, so November 1st, you've been approving her blanket email for 2 months, and then what did you respond in this email?
There are no parent or public events at the high school this week. The contact management plan permits you to request permission to attend particular events. Please ensure that all future events are for specific events and times, as blanket permissions are not contemplated by.
Okay, so you approved her for 2 months based on the blanket email. November 1st, 2 months later, you change and say, I want specific emails.
Not I. This was at the instruction of our attorneys.
Who sent the email?
I did.
So you requested from her to send specific emails per events.
Yes.
She has 2 kids in the school district?
Yes.
Both of them are playing sports?
I don't recall if Gavin was playing sports or not.
5 days in a week? If there was an event every day, that would be up to 10 emails a week, wouldn't it?
There's not an event.
I didn't ask you that. I'm asking you to answer my questions. If there was an event every day of the week, would you expect her to send an email for each kid being 10 emails a week? Was that your expectation?
At this point, the attorneys told us that was the
That's not my question, sir. That's not my question. Was your expectation for her to send an individual email for every child every time they had an event, even if it resulted in 10 emails a week? Yes or no? Was that your expectation?
I don't know.
So you don't even know what your own plan required.
That wasn't the event. That didn't occur. What occurred here is
Okay.
that she
Objection, Your Honor. This is non-responsive as can be. He's narrating.
I'll sustain the objection. I'll order that the last statement be stricken.
Sorry.
We're going to try this again, and I honestly don't understand why you're being so difficult. If there was an event every day of the week, there's 2 children, would you agree that would be 10 specific emails under what you're testifying to today? Yes or no?
Yes.
No. Yes or no?
Yes. Yes.
You would expect Michelle Pettitt to send you 10 separate emails.
This is what the lawyers told us the plan required.
Do you think that's a little unduly burdensome?
No, because
No?
there weren't events every day.
I'm not asking for an explanation. I'm asking yes or no questions. I'm throwing you softballs. You're an English teacher. You're not going to know the book.
Sustained. Mr. Cloud. Ask
All right.
the next question.
I'm going to move on. Have you ever told Michelle Pettitt that you turn your phone off at night?
I don't know. Probably, I may have, but once COVID hit.
Now, the PCM, you don't have it in front of you anymore, but we're going to go off your recollection. Does it state she can't use automated emails? Yes or no?
I don't recall that.
It doesn't, does it?
It was written before we even talked about it.
Okay. It actually doesn't state that she can't request permission for an event and then later change her mind and not attend that event either.
I don't understand. You mean, if she requested it and we said, yes, she'd have to attend?
No, if she requested an event and then something happened and she couldn't go.
She wouldn't be required to come.
Right. But it didn't contemplate her not going once she had requested permission, right?
Right?
Would she be preserving her right to attend if she was available by sending that email?
Possibly.
Parent contact management plan doesn't restrict emails from being sent outside of business hours either, does it?
It did not.
And nothing in the parent contact management plan restricts her from providing more than 48 hours notice, does it?
No.
So she could send out future emails for February, March, April, if she programmed them in November.
Yes.
That's not in violation of the plan.
Not of the original plan, no.
The parent contact management plan doesn't really contemplate any of the issues we just discussed, does it?
No, we contemplated the issues that are dealing with that illness.
Now, the PCM actually invites contacting you at any time, doesn't it?
I don't recall that.
Is there a line in there that says you can submit questions, suggestions, and concerns about your children's education via email at any time?
If you're reading it, then it says,
But you don't dispute that it said that then?
it's in there, it's in there.
That plan reserves the right for the school district to change it or amend it at any time, right?
Yes,
To your knowledge, was it ever amended?
it was.
And was it amended with a new date on the top?
I believe it was amended by letters from the district's attorneys.
So there's no letter stating parent contact management plan under a later date.
I don't recall how the letters from the lawyers became the record.
So if I'm looking at those letters and they don't say subject line or parent contact management plan, why would she consider that an amendment to the parent contact management plan?
I'm sorry, you're saying the letter doesn't say parent contact management?
No, it does not.
I don't know.
You never personally amended this, did you?
I didn't personally issue it.
Now, When this document was drafted, the parent contact management plan, what input did you have?
I was asked to write up a summary of this.
Okay. When this document was drafted, did anyone consult with my client?
Not that I'm aware of.
Did anybody give her the opportunity to contest the allegations against her?
Not that I'm aware of.
So your plan doesn't consider her busy schedule, does it?
It allows her to come to any event she wants.
That's not what I asked you. I asked you, when you drafted this, did it contemplate how busy her schedule is? You read that July 3rd email that Ms. Evans showed you, right?
Yes.
Okay. Just kind of a blanket email saying I'm requesting to attend anything you're participating in this week?
Yes.
All right. It was polite?
Yes.
There's nothing derogatory in it, right? It's not threatening, right? How easy would it be if you just, do you have an iPhone?
Yes.
How many emails a day do you swipe right on and delete?
And delete?
Hmm?
I mean, yeah, marketing emails, junk emails.
Junk emails. Junk emails. How many? A bunch. How hard would it be to delete one more?
Delete an email from parent? Just delete it?
I said how hard would it be to do?
It wouldn't be hard, it wouldn't be right.
Do you have to preserve all the emails you receive from the parents?
I'm pretty sure we would.
How do you preserve them?
You just don't delete them. They're in the emails.
Well, there's got to be a storage capacity on your email box.
It was a district email address,
So-
so the district storage.
So she didn't send enough emails to clog up your storage of your email then.
No.
You read the July 4th email?
Yes.
Is there anything offensive in that? Pretty polite, wasn't it?
It was in the middle of the night on July 4th, but yes.
But you don't remember telling her you turned your phone off at night, do you? You actually said you could have told her that.
But I didn't by the time that we were getting finished.
So you never told her that you wake up in the middle of the night to these emails, did you? So how would she know?
I don't know.
She wouldn't, would she?
No.
So she wouldn't know that you consider it harassing. Because she didn't know you were up checking it. Is that accurate?
Yes.
Thank you. See how easy this is? July 5th email. You read that one? Pretty polite, isn't it?
Nothing but. But, you know.
It's not derogatory.
No.
It's not threatening you in any way. Could have easily swiped right.
No, I could not easily have deleted an email from a parent. That's
Well.
not something that we would do.
Could have easily clicked archive.
And not responded.
Did you respond to every email she sent?
We did until they became such a flood, and that's when the lawyers asked her to restrict them to specific events.
So your testimony is that every email that she sent out, even after Justin graduated in May, you or Dr. Dorathy responded to every one of those?
We did.
Yes or no, sir?
Well,
Yes or no? Did you respond to him or did you not? You just said you responded to every email.
What do I do if neither yes or no is correct?
Mr. Cloud?
Yes, sir.
I believe the witnesses said,
That he responded to every email.
no, that isn't what the witness said. Okay. So the question was, sir, what was the date after May? Did you respond to every email? You can answer that yes or no.
After May, I was no longer the one responding. Dr. Dorathy was.
Okay. So you never responded to an email from Michelle Pettitt after May or after the graduation in May?
I don't recall the exact.
Okay. But you never responded to anything in June?
Not that I recall.
All right. I want to show you what.
33.
33. All right. I want to show you 33. It's already been admitted. I think we'll just publish it. All right. Do you remember seeing this email?
And Mr.
You
Cloud,
guys
if
close out the,
Oh, sorry. Try to make it bigger. Yeah. All right. Do you remember this email, sir? Actually, yes. Look at this. Is it? Yeah, there we go. All right. Second sentence of that is, but I'll remind you that I'm complying with the parent contact management plan that you yourself approved. Is that what that says?
It does. I don't know who you is. I don't know who this is addressed to.
Well, we haven't sent it, don't we?
Dr. Pettitt.
Right. Does that show her intent in sending automatic emails to comply with the parent contact management plan?
This doesn't say anything about automatic emails. And I believe that this
What is this last?
Dr. Dorathy, not to me.
The state highlighted, well, I assume the state highlighted.
I don't know why I only did.
The highlighted portion, the emails will be sent automatically. You know what that says?
Yes.
And the date of this was May 10th, right?
Yes.
Now, you were also shown a boomerang log, were you not?
Yes.
And the emails on that were started February 2nd, right?
Something like that.
So you testified that you started receiving tons of emails after this, but you were receiving emails before this.
I'm sorry, after what?
You testified that after you received this email, May 10th, you started receiving more emails from Michelle Pettitt.
If that's what I said, I misspoke. I meant we had started receiving a lot of emails much earlier.
Much earlier. All right. Now, let's go to the boomerang log. Hold on, let me keep publishing.
I think we need to close this out before you do that, so they don't see everything else that's in there.
Yeah, sorry. Am I still published?
Yep.
Yep.
All right. So should these iPads take a calendar off?
Do they what?
They don't have a calendar app on them.
They're just designed for the evidence. We try to keep them as minimal as possible.
All right, sir. Let's go to, this has been pre-submitted, it is Defense Exhibit 6. This is what's known as the boomerang logs. All right, you saw that document, sir, correct?
Yeah.
And that looks like it's from Boomerang Support, sending what log they have? Does that sound like what that is?
Yes.
Okay. Now, what did you say you said in the back during my opening statement, didn't you?
I heard some of it down in the office and then came in for the end.
Down in the office. Oh, you mean your office, sorry. All right, I'm gonna start with that first one. February 2nd. You know what day of the week that was?
No.
All right, I think we could probably take judicial notice of the calendar for 2022, but just for convenience, I Googled it. Okay. You have any objection on this?
No.
All right. What day is February 22nd? Or, I'm sorry, February 2nd. Jane, can you turn that one? I can zoom in.
February 22nd.
No, 2nd, February 2nd.
February 2nd is a Wednesday.
All right, I'm gonna go back to the log. The next one on there, February 6th, correct?
Yes.
What date is February 6th?
Sunday.
Sunday. So go back to the boomerang log. February 7th is the next email, correct? What date is that? What day of the week is that?
That would be a Monday.
Let's go back to the log. February 8th is the next email, correct? Do I even need to show you the calendar?
That would be a Tuesday. I believe.
Okay, Tuesday. Now, I don't know why I lost control of this. I can't scroll it down. There it goes. All right, the next email is February 9th. Let's go back to this. What day of the week is that?
That's a Wednesday.
All right. Let's go back to the log. What's the next date the email was sent?
After the 9th?
Yeah.
It's like the 13th?
All right. What day of the week is that?
Sunday.
Did it appear that my client was sending a blanket email on Sunday nights, asking to request any events, as she always had from the very beginning until 2 months later when you said it wasn't good enough. And then she was sending an email every Monday, and then she was sending an email every Tuesday, and then she was sending an email every Wednesday. Is that what that appears?
Yes.
Okay. Now, going back to this boomerang log, because she said these were waking up in the middle of the night. I'm going to go, let's just go to all right. These are the 3 emails in question. July 3rd, 4th, and 5th, right? I'm going to stand over here. Could you get me on the line about that, Judge?
Madam Clerk, if you could just make sure Mr. Cloud is picking up. Okay, go ahead.
The ones that are told me I was quiet.
Okay.
All right. What time did this email go out?
It says 0701.
What time did the email that you were shown by Ms. Evans say you received it?
Midnight, 1 o'clock? Something like that?
July 4th. What time does this ball say that email went out?
It says 11.
What time do you recall receiving it?
4? Right.
July 5th. What time did that email go out?
My eyes are 63.
And Gene has it.
Oh, okay, thank you. 8 o'clock.
What time do you recall receiving it?
Midnight or 1?
Seems like there's some kind of discrepancy here. Maybe some type of mistake was made.
Mm-hmm.
Could it be that,
Sir, we'll need you to answer yes or no.
Yes.
could it be that you were receiving the emails in Mountain Standard Time? They were being sent out 7 hours delayed on Universal Time?
Objection, call for speculation.
I'll sustain the objection.
So, at the time you received that May 10th email, saying, I'm going to keep sending emails, you had already been receiving those emails Sunday,
Monday, Tuesday, Wednesday.
Yes.
Right. You've been approving her to attend her children's sporting events from those emails.
Until some point in the process when Dr. Dorathy was. Yeah, there was a point at which she began responding.
All right. So either one of you was responding, allowing her to attend events based on how she felt she was complying with the plan.
I'm not sure that either one is right, because I did it to a point, and then Dr. Dorathy did it after that. So it's not that we did it.
Do you recall when you stopped responding?
I want to say sometime midwinter,
Midwinter?
February, something like that, but
So you never responded after that?
not that I recall, but that doesn't mean that Dr. Dorathy wasn't traveling and I responded.
What did you do with the emails when you received them?
If Dr. Dorathy was already on them, then I waited to see if she would respond.
Then you just ignored them.
No, I read them and then I checked with Dr. Dorathy.
Okay. And
And
then,
she would hit reply all, so I would see the response.
okay. Just to be fair, she was approved based on those automated emails, right? You're not disputing that.
No.
The calendar you were showing, I believe it was Defense Exhibit 12. Do you recall that?
Athletic calendar?
Yeah. That was only spring of 2022, right?
Correct.
Would there have been events, I'm just going to publish this, it's been admitted.
And can you take off the left side? Thank you.
Sir. I'm sure it's not. I don't know if that's the internet or. There it goes. All right. Now, you told me you didn't dispute this, but down in the corner it does say, and I don't know if you circled that, but it does say dates and times of all events subject to change, right? All right. Now, these events that we saw, that's only spring 2022, right? It's just the football calendar on there?
No.
What part of the school year is soccer? Is that fall?
I'm sorry.
What part of the school year is soccer?
Soccer is winter.
It's winter? Is that on that?
No.
So there's other events that you approved her for that are not on this calendar, right?
Yeah.
So you said this has 50, and then there's some, that was your testimony, you said this, oh, it was Miss Evans' testimony, wasn't it? Yeah. All right.
Half of those were away.
Yeah, and half of those are away. So 25, 2 kids, it's 50 emails, and there's also August, September, October, November, December. Well, let's not count, hold on, let's not count August because that's when they're there. There's 4 months, September, October, November, and December. Those are months where she sent emails where either you or Dr. Dorathy approved her.
Correct.
So that could be another 25.
Well, it wouldn't be 25 because it's not like the boys were playing softball. I mean, these are men's sports as well as women, and they weren't playing more than one sport at a time, so it would be.
That's fair. But it was certainly substantial. And it was both the fall and the spring. So if she's sending out 4 emails a week, are most games Wednesday, Thursday, Friday, Saturday?
Football games are almost invariably on Friday. The others fall through the week. We're often have Monday and Tuesday games as well, or weekend games.
Is Miami school district on 4 day-a-week calendar?
We are.
So Fridays, they might have games like midday.
Actually, they usually fell on other days as well. Yeah.
Last thing I want to ask you about is the graduation date. That graduation date was picked before that school year started, right?
Graduation is always the last Friday before Memorial.
And that's on the calendar at the beginning of the school year, in August.
Yes, sir. Yeah.
So, do you include a school event, like the open house when you enroll the kids and the parents are there?
We do.
Am I client need permission to attend those?
Actually, the last one that I know of would have been before the contact management plan was issued.
But by the time of the parent contact management plan, she would have known when graduation was going to be.
Yes.
So if she sits down with a calendar, and after you sent that November 1st email asking for specific emails, she would have saw that on that calendar.
She could have, yes.
Does public voting occur in Miami Unified School District?
Yes.
Does she need permission to vote?
I don't know I don't know exactly the answer to that, but it's not that we're going to stop somebody from coming to vote.
When did you leave the district?
June 30 of 2023.
Exactly 1 year after the injunction. No? All right. Well, sir, that was a little painful, but I think I'm done. All right. I have no more questions for you, sir. Thank you.
Ms. Evans, any redirects?
Yes, sir. Let's begin with the reason the parent contact management plan came to place. I think Mr. Cloud gave us a little bit more context on that. So you said that this was after COVID, and you didn't quite understand how email CCs versus BCCs work?
When COVID started, it was the first time that we had ever sent blast emails out to all of our students.
That was
In fact, it was the first time we had signed email addresses at junior.
okay.
And so we were learning during COVID. So we were just getting the emails out, and because kids were working from home, there were often daily emails to the students and to their parents.
Okay, just to keep everybody informed of what's going on?
And then we had hybrid schedule, which meant half the kids were there on 2 days and at home the other 2, and that meant the ones who were at home, we had to send out the lunch delivery schedules. Right, so there was a constant need for communication during the time.
And as things often happen, mistakes were made?
Yeah.
And did that include allowing everybody on that email chain to see all of the students' emails?
I'm afraid it did.
So people then had access to these.
Yes.
And using that, Michelle Pettitt thought it was appropriate to send every student in school potentially embarrassing information about you?
Yeah, to minor children who weren't allowed.
So essentially weaponizing the students against you.
Objection.
He brought it up, Your Honor.
Weaponizing?
Just like sustained, I'll sustain it on argumentative grounds.
Essentially trying to inform the students of potentially bad information about their principal.
Yes.
All right. And do you believe she did that because she didn't like you?
By that time, she did not like me.
And did she express that to you?
Yes.
Did she say that in no uncertain terms? So, Mr. Cloud made a big deal about the PCN. And you said that you were a teacher and you did not think that that was unclear. And I think he interrupted you a lot, so I'd like you to be able to complete that. Why do you think that that was clear?
So the contract management plan laid out the history and the policy and steps to protect Mrs. Pettit's interests as a parent and evaluate her kids' education, and then steps to protect the school and students and staff from harassment. And then there were exceptions that laid out how she could attend events on campus or communicate with us. So one of the exceptions was that if she wanted to attend an event, then she would request permission 48 hours ahead of time to attend the event. So, sorry, I'm an English teacher. To me, a event means any event on the calendar, and the event means the one in particular that we're talking about.
Okay. So I'm a lawyer, but I'm not an English teacher. So would the word a and the word the be counted as articles?
They are articles.
Aha, I got it right.
The others.
No. And would a and be general articles?
Yes,
Meaning it could refer to a group.
we could.
Okay. And would the be considered a specific article?
It is.
So when you say the event, you mean a specific event?
Correct.
Okay. So trying to argue it a different way is splitting hairs.
Yes.
Okay. So, at some point, you realized that there was an issue with the current parent contact management plan. About when was that? Was that around November?
I think it was. We realized that the request to attend things, and again, we never denied the request, but we started getting requests, so many requests, that a lot of them were when there was no event at all, or it was an event that you didn't have a child participating in, or it was an event that was located someplace else. And so at that point, the lawyers believed, and the lawyers asked them to be more specific.
Okay. And in fact, I think that Mr. Cloud introduced evidence that showed that she sent an email to attend event on October 31st, and the reply was, there's no events to attend.
Correct.
So that was one of those many non-existent events she requested to attend.
Right.
And why was that problematic?
Well, first of all, it just requires response time for something that shouldn't exist. The second, it raised concerns that we might be missing something. We could be missing approving a request that we didn't realize was there, or that she was trying to get permission to come to something that she didn't have to participate.
So at that point, did you realize there was a problem with your current plan?
Yes.
And that was that she was being allowed to request to attend events that didn't exist.
Right.
And this next letter, I think Mr. Cloud pointed out that it didn't say parent contact management plan.
I don't recall. I haven't seen a letter since it was sent.
But it was a letter from your attorney.
Yes.
And was it one of those cease and desist letters?
Probably so, yes.
And did it specify that she did need to request to attend each specific event?
I believe it did. And you asked me to remember something from 2 years ago.
But either way, there was a letter like that.
Yes.
So saying that this doesn't say parent contact management plan, again, splitting hairs?
Yes.
Now, Mr. Cloud said there's a lot of events she could request to attend. Did she attend every single event at the school?
No.
In fact, I think he said that you never contemplated her busy schedule. Would she have been basically at the school all the time if she wanted to attend every single event? Okay. And is it that burdensome to send an email to request an event 2 days beforehand if she's not doing it every day?
No.
In fact, I think the boomerang email logs show that she's not asking every day,
Correct.
just most days.
Correct.
So I think Mr. Cloud also pointed out that of the spring sporting events, there were even more events that could have occurred before the spring schedule. Is that right?
Well, there would have been fall schedule and winter schedule, yes.
Okay. But the boomerang email logs that contained those 140 events, that started in February.
It did. February 2nd.
And that calendar covers February through May.
Yes.
So there was 50 in that time period events and over 100 emails in that event.
There were 50 total events. Yes.
And at least double the amount of emails.
More than that, because half those events would have been someplace else, or away games, or away matches, or away meetings.
So for that,
And another, and half of those were women's games.
and she doesn't, and suffice to say, Justin and Gavin are not women.
Correct.
Just to make sure. So there's even less than 50.
Probably 15, 20.
So there was no reason to send that many emails.
And maybe fewer than that, because I'm not sure that Justin and Gavin have done the sports sense.
Okay.
I don't know. I'm not saying they weren't. It's just
Okay. And that's fair. It's been a few years. Okay. So I think you were also talking about how you didn't respond to necessarily all of the emails. But were you involved in every single email?
Yes.
What would happen if the school did not respond to every single one of her emails?
Well, first of all, we would be meeting our responsibility. I mean, it's our job to respond to parents. And then I'm sure something would be made of it.
Okay. So you had to take some sort of action on every single one of these
It
emails.
was taken on every single one.
So it wasn't just as simple as swiping right.
No, and I don't recall ever deleting an email from a parent.
Why not?
Because sometimes you need the information, and because sometimes, yeah, I know, it's just, that's what we deal with. So you don't emails about personnel, you don't delete emails about student well-being, you don't delete communications from parents.
All right. So I think that Mr. Cloud was trying to allude that for some reason you just didn't think that she was doing enough and you wanted her to be more specific. Is that true?
We wanted to make certain that we were being responsible.
So the reason why you wanted her to be specific was because she was asking to attend things that didn't exist.
Or that she had no involvement in it. Right. We wanted to prove anything that came out that was legitimate, but the raw emails didn't give us enough information.
So this wasn't an arbitrary change. There was a reason.
There was a reason, and it was a discussion with the attorneys, and the attorneys settled it. Right.
And going back again to even the creation of this PCM, was that blanket email where she tried to defame you to all the students, was that the only reason for the parent contact management plan?
No.
Were there other reasons?
There were other issues in fact.
Let me just check my notes. Okay, so I think that the last thing I need to discuss is they pointed out that that these schedules were subject to change. How often did they change?
Well, they changed occasionally. We had to get a baseball game rescheduled my last year there because there were massive storms and somebody, St. John's or somebody, couldn't get down the highway. You have schools with conflicts in their calendars. They're probably in each, not in golf and track, I don't recall changes. In the spring, in baseball, softball, tennis, there's probably a change in each sport each year. And certainly changes can happen that because of whether a team is coming over earlier and we're going to play at 2:30 and 4:30 instead of 4:30 and 6:30. So I mean that's why it's on there. Things can change.
Did it change enough to warrant another 50 emails?
No.
And
if your kids are playing in the game, then you should have an information source about those games.
And was there any reason to send around 20 whole emails to attend one event?
We're talking graduation?
Yes.
Yes, no, I mean, Dr. Dorathy responded with the time and permission to either the first or second email. So the other 18 or 19 emails over the next month were just extra.
And again, that May 10th, 2022 email, she acknowledges that these emails were time-consuming and bothersome.
And that she already had the information on graduation, yes.
Nothing further.
Members of the jury, this is your opportunity to ask questions. Do any of you have any questions for this witness? There's a question form in your notebook. So, counsel, can I see a sidebar while the jurors are filling those out? Mr. Cloud. Okay, I'll go ahead and start looking at that one of those while we're doing this. Can you route these to Mr. Cloud first and then to Ms. Evans? Okay, that's fine.
Do you want to do sidebar, Your Honor?
I want you to look at them first and see if we're going to need to have a sidebar or not.
That was, yours?
Yes, I put that on there.
Oh, was that your information?
Yes. I'll go ahead and see those. Oh, sorry, I didn't tell you them all. Just a second. Okay. Members of the jury, I'm going to need to speak with the attorneys for just a moment. Let me give you an idea of what the rest of our afternoon looks like. It's 4:30 now. My plan is I need to talk to the attorneys briefly about the questions and about a couple other things. Then I'll work on the questions. After that, I'll give the attorneys a short opportunity with any follow-up, and then we're going to finish for the day. So we're close. We're still on time. I'm going to excuse you, hopefully for about 5 minutes, and then I'll have you come right back, okay? So I'll excuse our jurors. Counsel, if you could just remain. Okay. Ms. Evans, can you bring me up that last one?
Yes, Your Honor.
Okay. And actually, counsel, if you want to step forward, I'll let you look at number 4 that was just given to me. You can look at 3 at the same time. I think you'll understand why I'm giving you both of those together. You can go. Everyone can have a seat. They were seriously written at different times. So, yes.
Same person?
Yeah, he said he had a couple of fire.
Oh, maybe that's it. Okay. Well, we'll talk about it. Okay. Okay. Go ahead and have a seat. I'll note the absence of our jurors. Just briefly, we had a sidebar that was on our scheduling. My plan is going to be, as I told the jury, and then we're going to start again at 9:30 tomorrow. It sounds like Mr. Sanis may not need to be called. Counsel, if there's a stipulation regarding that, I find it helpful if you can write it out and I can read it. If there needs to be a stipulation, if it was covered elsewhere, that's fine. Okay, first jury question. Is this case based only on emails sent July 3rd, 4th, and 5th of 2022? That's a legal question. I don't believe it's appropriate to ask this witness that. I am hopeful that either your closing arguments or my instructions will provide direction there, but I don't think I'm not going to submit it to this witness. Anything you want to be heard on that, counsel? Nope. Okay, I see nothing. Second one, Madam Clerk, I'll give that to you. The second question had 2 parts. First parts, when were the letters from the attorneys, quote, amending, close quote, the PCM sent? It seems appropriate to ask. I'm not sure the witness is going to be able to answer that, but it seems appropriate to ask. The second question, is there a reason the PCM was originate? Is there a bottom of the iceberg we should know? I'm not inclined to ask that question. So, Mr. Cloud, first, any issue with me asking about when the amending letters were sent?
Your Honor, I do. I've never heard, these are cease and desist letters. That's what they're always referenced to. That's what the title of the document is. That's what it was called when it's listed as intended. I've never heard of it as an amendment to the PCM. I think that greatly miscategorizes it, and I think we talked about on Monday, we went through them, and they don't even deal with the same events or restrictions of the PCM. They talk about the fake email addresses, they talk about the sexual assault thing. So they're not amending the PCM in any way. I just object to categorizing them as amendments.
Okay. Ms. Evans, what do you think about that question?
I think it's a fair question, although Mr. Lineberry may clarify that they were cease and desist letters that reference the PCM.
I'm going to ask the question. Mr. Cloud, you'll be able to follow up. The amending was not it's the jurors. So I'm going to ask that. As far as the second part, counsel, I'm not inclined to ask that. Mr. Cloud, would you like to be heard on that?
What was the second part again?
What's the reason the PCM was originated?
This is why I asked for the sidebar, Judge. I think when we came in this morning at 8:30, I told you we have to tell the story. The jury wants to know the story. I think we have to tell them why it was originated. It's a sequence of events. It means, like Ms. Kayla says, this is a tip. This is a tip. They want to know what's under the water, why it was put in place. It's relevant.
I'm sorry, Kayla.
Go ahead.
Okay. I've asked the court all along, the case in this. A lot of this, to be honest, is to protect the defendant herself, because a lot of the information we would have to get into reflects very poorly on her, including her anger at the custody dispute and all of the other things. We're just getting into a lot of litigation that just does not need to happen in her.
I'm not going to ask number two. I'm going to find that the reason for the parent contact management plan is really not relevant to whether the emails that were sent on July 3rd, 4th, and 5th are harassing. I've been allowed the parties to introduce the actual, that it was there and the requirements, but the reason for it, I'm going to find, is not relevant. Okay. Next one, and the next two, 3 and 4. 3 reads, was a complaint of harassment from the witness ever submitted to the defendant? 4 reads, was a complaint of harassment from the witness ever sent to the defendant prior to the injunction being filed? I'm inclined to ask the 4th one, not ask 3, as 3 is duplicative of it. Mr. Cloud, do you have any objection to that?
I don't have an objection, Your Honor. I do want to say this one thing about the last thing, is that I think that the origination of the PCM goes to my client's mental state or intent, but if you think you will not abide by it, I just want to put it on the record.
Thank you. Ms. Evans, any objection if I ask the question number 4?
No, Your Honor.
Okay. So, Madam Clerk, I'm going to give you number 3 as not asked. I'll plan on asking question 2, part 1, and question 4 of that. Okay, counsel, after I ask those 2, I'll give each of you an opportunity for a brief follow-up related to the juror questions, and then we'll plan on breaking for the evening. While our jury is out, you indicated you're going to call Dr. Dorathy tomorrow morning.
Yes.
Okay. Okay. And counsel, anything else then before we bring our jury back for their brief final stint? I don't see anything. Okay. Gene, we're ready for the jury back. Thank you for that. I have to start doing hour stand-ups. Okay, please be seated, jurors, when you come in. But everyone's standing for you, so you can have a seat as you come in. And then, okay, I'll note the presence of our juror. Please be seated, everyone else. Jurors, thank you for your indulgence. I think you are the most prompt jury I've ever had. I've never ran into a jury 2 or 3 times in the hallway, all lined up, so thank you. Okay. Dr. Lineberry, several questions for you. When were the letters from the attorneys, quote, amending, close quote, the PCM sent?
Well, I don't recall exact dates, but I believe one of them went in about November after the parent contact management plan was implemented in August, and the other one sometime in the spring semester.
Okay. Another juror question. Was a complaint of harassment from yourself ever sent to the defendant prior to the injunction being filed?
Well, by the time the injunction was filed, she had the parent contact management plan to cease and desist letters from the lawyers. So I would say yes, I didn't send it back. No.
Okay. Ms. Evans, any follow-up to the juror questions?
So the dates, November 12th, 2021, and January 14th, 2022, sound about right for those cease and desist letters?
Yes.
And was the point of the cease and desist letters to inform the defendant that her actions were problematic?
And actions that came after the original contract position, yes.
And was part of this to clarify your intent in the parent contact management plan?
Yes.
And do you believe that by at least May 10th of 2022, she was fully aware of the problems her emails were causing? I'm finished, Your Honor.
Mr. Cloud, any follow-up to the juror questions?
Just briefly, Your Honor. Mr. Lineberry, you never personally told my client you felt harassed by her emails, correct?
I did not.
These, what you're calling cease and desist letters, are what you referred to earlier as amendments to the plan,
Yes.
but they didn't make any changes to the plan, right?
I guess we thought they were clarifying that.
So they tell her to stop doing one thing or another, but did they actually change anything in the plan?
I don't know.
To your knowledge, a new plan was never sent to her.
I do not know what new plan is.
Thank you. I have no further questions.
Okay. Thank you. Thank you, Dr. Lineberry. Why don't you go ahead and have a seat? Okay. Members of the jury, we're going to break for the evening now. Talking a lot about school. I always think if you're getting out of school 23 minutes early or 20 minutes early by the time I quit talking, please remember the admonition that I've given you. You can't do any research. You can't talk to anybody about the case. A story I like to tell, President Lincoln, before he was our president, was a trial lawyer. And at his last trial, the judge, not Mr. Lincoln, then later President Lincoln, he admonished the jury similar to what I am admonishing you, not to talk to anyone about it. Now, you can imagine in the late 1800s, there wasn't any women on the jury. So he told the gentlemen who were on the jury that they would, when they got home, they were not to tell their wives about what the trial was about, even if she were to withhold their dinner. So times are different. Some of you may go home, some of you ladies, to your significant others making dinner for you. But either way, you can't tell anybody about what's happening, which is somewhat difficult, because I'm sure that's going to be their first question. You can tell them we're here today, tomorrow, Friday. You can tell them that I'm the mean judge who said you can't talk about it. Okay, so please remember that. Okay, I'm looking at, how many of you are from up north? It looks like most of you. I'm looking at the weather. Tomorrow the weather is supposed to be beautiful, with a little bit of fog in the morning before 8. So we're going to start at 9:30. So hopefully that'll give you a little bit of a later start. I think sunrise right now is around, I don't know if I have it on this weather page, 7:10, 7:20, somewhere around there. So hopefully you can be on the road when it's light and not when it's dark. We can deal with fog. If you need to go slower tomorrow morning, I would much rather us start 5 minutes late and have you here healthy than you say, oh my goodness, I'm running late, I don't want to be late. Don't push it if there's any ice on the road or fog on the road. So we'll start at 9:30. With that, I will excuse our jurors. We'll see you tomorrow morning. Okay, I'll note the absence of our jurors. Counsel, please be seated. Just one thing that I've thought of. Counsel, I don't believe either of you invoked the rule of exclusion of witnesses. It was somewhat unrelated. It came up today, but I don't think the rule had ever been invoked. Many times I ask that, are either of you going to invoke the rule moving forward? And I just want to clarify so we're clear. If neither of you are going to, that's fine.
That
Okay.
only needs to be moved because the witness has already testified and.
Okay.
And Dr. Dorathy was already excluded from the courtroom,
When
so.
it's the case agent.
Okay.
It's the case agent,
I just,
so.
because it came to my mind when I heard that the witness had heard openings, which he hadn't been advised not to, but under rule, I think it's 9.3 in the criminal rules, the exclusion applies to openings as well as actually other witnesses as
But he's
well.
also a named victim, which is why I said it's fine.
Oh, okay, there we go. Okay. Okay, Ms. Evans, and anything before we break?
No, Your Honor.
Okay, and Ms. Evans, tomorrow morning, if you can have Ms. Dorathy in the courtroom, we'll have her on right at 9:30. Mr. Cloud, anything else?
No, but what's the plan? Dorathy first, then we get hopefully before lunch, and my plan in the afternoon.
Yeah, based on, because today you were able to do Mr. Lineberry, I'm looking, he started at 2:15, so actually you did him in about 2.5 hours. So if we started, that should take us to 11, and then maybe a deputy before lunch. I'll let you know, the clerk pointed out to me, and I noticed, one of our jurors, her eyes get droopy. I don't know if they'll get droopy, but then they'll open right back up, and she appears to be with us. I may start stretching every 45 minutes to an hour just to make sure we do that. I don't like calling out witnesses, and I'm not ready to give her, our jurors, and I'm not ready to give her up as an alternate because I don't think there's a reason yet, but I may do that, and now you'll know why I may do that.
I will note that it is a little warm in here for me, so maybe if we turn down the thermostat, that might help a little bit. I know that when I'm warm, I get.
Are you warm, Mr. Cloud?
Absolutely.
Okay. Actually, believe it or not, I'm not warm, and I'm usually have to wear the extra garment, but have you been warm? Okay. Well, what's if you can look at the temperature, 74? Okay, that's too warm. Madam Clerk, when we come in tomorrow morning, let's look for 71 or 72 probably. Fortunately, this time of year, our jurors are going to have jackets, so if they need to, and if they all come out without jackets the first time, I'll ask them if they want to go back in just in case.
To be fair, my husband keeps the house at 66.
My husband keeps ours at 62.
That's ours is 60. Ours is at 62 in the winter as well, so it's a little chilly in the evenings. But sweatshirts are free. So, okay. It is. So anything else? We'll go off the record. We're off the record. So I read a book on